Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, everybody. Welcome back. We have several things to cover today, and two of which are verdict watches. We have not heard anything yet on either one of the verdict watches, but we got some things to watch in the meantime. We got some things we can do in the meantime. Welcome, everybody. Thank you so much. Hello, Miss Yana, June, Gerald. One sunny day, Jesse. Thank you so much, y'all, for joining. We greatly appreciate, and all of you who are joining, who did not say hello. Thank you so much for joining. We have multiple things to talk about today, and we are waiting. We are awaiting two verdicts. And my camera keeps, I don't know how that does it. It just kind of gravitates. I guess gravity does it. So right now, we have Monica Sementilli, who is still in verdict watch. We're going to go back and watch one of the questions and go back and look at some of that in a minute. I'd like to kind of go back and review the questions. But today, first on at base or at bat is going to be the Sturmer trial, because they did the reading of the instructional reading today. So we're going to watch a little bit of that, because I want to hear the charges again, and I want to hear how they're phrased, because that to me is very important. And I think that sometimes juries do get hung up on that. Do you think they'll come in today? On which case? I hope the Sementilli for sure. It'd be interesting if they come back so quickly with the Sturmer. Here we go.
The defendant is not required to prove her innocence or to do anything. If you find that the prosecutors have not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way.
That's the mother of the victim.
When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you must give the statements whatever weight you think they deserve. In deciding this, you should think about how and when the statements were made and about all the other evidence in the case. You may consider the statements in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witnesses said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called a stipulation or stipulated facts. You may regard stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutors do not have to prove that the defendant had a reason to commit it, the alleged crime. They only have to show that the defendant actually committed the crime and that she meant to do so. The testimony of Dardita Gordon was read into this trial because she was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you've heard in court. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses, and there's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from expert witnesses. Dr. Michael Markey gave you his opinion as an expert in the field of forensic pathology. Dr. Dave Hayhurst gave you his opinion as an expert in the field of DNA analysis and forensic biology. Ann Hunt gave you her opinion as an expert in the field of serology and DNA analysis. Troy Ernst gave you his opinion as an expert in the field of fire debris analysis and trace evidence. Scott Leroy gave you his opinion as an expert in the field of fire investigation and cause and origin. Robert Trenkel gave you his opinion as an expert in the field of fire investigation, fire suppression, and fire inspection. I'm going to try my best, Zujetsky gave you his opinion as an expert in the field of injury biomechanics. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. During the testimony of Robert Trenkel, videos were admitted as evidence to illustrate his testimony. The parties agree that the videos are not in any way a recreation of the events at issue in this trial. You may only consider the videos to help you understand and evaluate this witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions, and how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. During the testimony of Robert Trenkle, a pair of gray polyester sweatpants were admitted as evidence. The parties agree that these sweatpants are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. You've heard testimony from witnesses who are police officers, and that testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, defendant is charged with first-degree premeditated murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Sturmer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Sturmer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant intended to kill Todd Joseph Sturmer. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case.
Whoa, something's happening. Something's happening. Let's get over there. Come on, sound.
Counsel. Please confirm if on page 51 of your 7/7/23 sentencing order,
Really?
line 19 and 20, your reference to special circumstances, plural, refers to financial gain and line and weight, People's Exhibit 276. So I have People's 276 in front of me, which, by the way, was originally a two-sided page. Every other page is missing from this. For example, I have page 1.
Wait a minute. My bad. What is going on? Hold on. Why do we have... Okay, we're going back over here. It was an earlier time.
Without
My
thought
bad.
or reflection.
Woo, had a
You
heart
may also
attack.
consider the
I don't
lesser
know why the
charge of
video
second-degree
starts standing up on
murder.
its
To
own.
prove this charge, the prosecutors must prove each
I
of the
want to
following
look at
elements
that.
beyond a reasonable doubt. First, that the defendant caused the death of Todd Sturmer. It is not enough that defendant's
Got
act made it
something.
possible for the death
My
to
bad.
occur. In order to find that the death of
My
Todd
bad.
Joseph Sturmer was caused by the defendant, you
And
must
my
find
time is
beyond a
up.
reasonable doubt that the death was the natural or necessary result of the defendant's act.
Deleting my comment.
Second, that the defendant had one of these 3 states of
My bad.
mind. She intended to kill, or she intended to do great bodily harm to Todd Joseph Sturmer, or she knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of her actions. In count 2, defendant is charged with first-degree felony murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death
They
of
don't
Todd
have a
Joseph
time
Sturmer.
clock up on it. Hold on.
It is not enough.
They do not have a time clock on this today. Okay, well, they have not started in the Monica Sementilli yet, so we're good. All right, we're safe. We're
That the
good.
defendant's act made
Oh,
it possible
well.
for the death
Good morning,
to
Ms.
occur. In order to
Morales.
find that the death of Todd Joseph Sturmer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these 3 states of mind. She intended to kill, or she intended to do great bodily harm to Todd Joseph Sturmer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Todd Sturmer, the defendant was committing the crime of arson. To prove the crime of arson, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant burned a building or any of its contents. The term burn in this case means setting fire to or doing anything that results in the starting of a fire, or helping or persuading someone else to set a fire. If any part of the building is burned, that is all that is necessary to count as a burning. The property does not have to be completely destroyed. Second, that at the time of the burning, the building was a dwelling house. A dwelling house is a structure that was actually being lived in or that reasonably could have been lived in at the time of the fire. Third, that when the defendant burned the dwelling or any of its contents, she intended to burn the dwelling or contents or intentionally committed an act that created a very high risk of burning the dwelling or contents, and that while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes. The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You may also consider the lesser charge of second-degree murder on this count. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Sturmer. It's not enough that the defendant's act made it possible for this death to occur. In order to find that the death of Todd Sturmer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind. She intended to kill, or she intended to do great bodily harm to Todd Joseph Sturmer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her action. The prosecutors must also prove beyond a reasonable doubt that the crimes occurred on or about January 7, 2007 within Van Buren County. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutors need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. When you go to the jury room, you'll be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin your deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. The exhibits admitted will be available in the jury room for you to review. You've been given a written copy of the instructions you've just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. Defendant is charged with 2 counts, first-degree premeditated murder and first-degree felony murder. These are separate crimes, and the prosecutors are charging that defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of both or either one of these crimes, guilty of a less serious crime, or not guilty. I've prepared a verdict form listing the possible verdicts. You will have on your verdict form as to count 1, the option of not guilty, guilty of first-degree premeditated murder, or guilty of the lesser offense of second-degree murder. And as to count 2, the option of not guilty, guilty of first-degree felony murder, guilty of the lesser offense of second-degree murder. Counsel, any objection to the fine? Yep. Thank you. Did I miss?
Okay, guys, so there you have it. There was the instructions for them. We are now, as Miss Yana has reported, 2 hours, I think about 29 minutes into this now. On their end, Monica Sementilli, they have yet to start their jury deliberations. I kept thinking that they should have already been, but they haven't. They'll start those shortly. I want to share this exchange that happened yesterday concerning the Monica Sementilli trial. Listen to the question. The Sturmer verdict clock is at 2 hours and 30 minutes. Thank you so much. Monica, they were going to start at 10 o'clock their time. That's 11 o'clock my time. And then on top of that, there's a 30-minute delay. So that's how they roll. But I want us to hear the question and what happened yesterday. Let me go back and find it. That was that one. Okay, let's hear the question yesterday.
Appearing via WebEx, the jury and also not present. I received the following communication, which I share with counsel. Please confirm if on page 51 of your 7/7/23 sentencing order, line 19 and 20, your reference to special circumstances, plural, refers to financial gain and line and weight, People's Exhibit 276. So I have People's 276 in front of me, which, by the way, was originally a 2-sided page. Every other page is missing from this. For example, I have page 1, page 3, page 5, etc. But going to page 51,
I got the proof.
Lines 19 and 20. It says, for the crimes which the defendant has been convicted, in count 1, murder in the first degree, in violation of section 187, subsection A, with the special circumstances, plural, having been found true, it will be the judgment sentence of the court as follows. And then I went and imposed judgment. The defendant, or the former defendant, Baker, pled straight up. I took the plea myself. I took independent admissions of each special circumstance. And I'll hear from counsel in a moment, but my proffered answer is yes. It refers to financial gain and line and weight special circumstance. Now I'll hear any objection.
Yes, Your Honor. The basis of my argument to the jury was the transcript that was marked and sent back to the jury, and also basically what Mr. Baker was told at the time of the entry of his plea. The point was that he would not have entered a plea had the name, the conspiracy with Monica Sementilli, which was contained in the indictment, but was not read either by the court or by Ms. Silverman when she took the waivers and said, this is what you're pleading to. And the point was not that Mr. Baker's sentence is not in question. It's not as if he's arguing on appeal that there were no special circumstances that he pled to, therefore the plea's invalid or anything. This was all based on what was said to him in open court and why he agreed to the plea. He could have not agreed to plead open. And it was our argument, had it said conspiracy with Monica Sementilli, he would not have pled open, and only pled open to what is in the transcript. So I would ask the court to just refer the jury to the transcript. It's not a question of what the court intended, because Mr. Baker got what the court intended. It was what was the impact of the words to Mr. Baker when he chose to enter.
That is not what the question was. The question was relating to my words when I did the sentencing. When I referred to the special circumstances, was I referring
Here we
to
go.
financial gain and line and weight? And that's exactly what I was referring to.
But if he's pleading special circumstances, it doesn't matter what they are. He still gets life without parole. So it didn't, the court either should have said, with all respect, read them, or understood that as long as he's pleading the special circumstances, frankly, it doesn't have to be two, it only has to be one, I believe.
Except it was two.
It was
And
two
I said that in the plural.
It was two, fine, and so he pled the two special circumstances, and he understood that, but it was not read to him. That was my only point, and the court didn't read, why didn't the court read the letter of the indictment, which was Monica Sementilli, conspiracy to commit murder with Monica Sementilli? That was not read either. It's my belief that he would, if it had been read, he would not have agreed to enter the plea, which was his.
Again, that's not relevant. What is relevant is what
Was relevant to my argument to the
But he
jury.
pled to me, and he pled to me.
Gerald.
Admitted each individual special circumstance that was charged, and I sentenced them to the murder with special circumstances.
All right, I'll just make my point.
Okay.
It's not what the court. This trial is not what the court meant in the Baker sentencing. That's my point.
Y'all, I agree with you, Ronnie. For a 40-year-old, now 50-year-old woman to be doing what she did is raunchy, nasty, dirty, disgusting. Ho! That's how I feel. I'm not high.
I know what the court meant, and if there was an issue of the sentencing of Baker, the only point to even get into the transcript in this trial was that those words were not said, and Mr. Baker was not admitting to those in front of the court and the jury, court, and we don't know what he would have done if the court had read Monica Sementilli and so forth, and I believe his statement that she was never involved was meant to, when he pled, not to incriminate her in any way. Her name's not mentioned. I don't see why the court can't just refer them to the transcript, because the court's intent in sentencing Mr. Baker is not an issue in this case.
I understand that, but that was not their question.
And Your Honor, if I just may add one
All right.
brief point. I believe the juror's question is asking for Your Honor's state of mind in your reference to the special circumstance referred to in the transcript. And respectfully, we do not believe it would be appropriate for you to give your state of mind, your intended reference to which special circumstance in response to this question, other than just indicating that was what was said by the court to Mr. Baker.
On page 51.
That is not what was the question that was asked, and it wasn't asking
Wow.
my state of mind. But I appreciate that. Your record is made. Do people have anything that they wish to say, Ms. Sorman? Ms. Sorman,
Judge, that was why I objected during the argument. I didn't take the plea. You did. So I think that their question is exactly what the court has indicated for the record.
Okay, thank you. I am going to do my original answer.
Yes, the answer is yes.
Over our objection, obviously.
Actually, the question, and it is over your objection, it won't be yes, it'll be confirmed. Please confirm if on page 51, et cetera, et cetera.
Yes.
Please confirm, the answer, which should be yes, if you're going to answer it, then it's positive, not, I don't think you're confirming anything, you're answering yes as to what you, well,
I understand.
I've made the point.
You did very well on the
Thank
two.
you, woman.
You just sent back along with the exhibit.
Amen,
The
June.
exhibit fell apart.
Amen. I want to break out in that amen chorus. Amen. Yeah, definitely want to do that. That's an interesting ruling. I don't know if that's going to help them or not. So right now we are in on, let me get the screen share back up. Verdict watch is on this trial 8 hours, 17 minutes, and 14 seconds. The verdict watch on this trial, we don't know. I'm going to say 2 hours and 40 minutes. Oh my gosh, June, thank you so much. Erin, you received one. Catherine, Penny, Cali Girl 15, Elena, Yana, woohoo! Thank you so much for the gifted 5 memberships. Okay, so the poll right now says in the Sturmer trial, how long till we reach a verdict? 2 to 4 hours, 31%. Well, we're in that still. 4 to 6 hours, 38%. 19% said 1 day. And 12% said 2 to plus days. We're going to end the questioning, confirm, because we've already done that. So the poll has posted. Thank you so much, June, for the gifted memberships. Really, we really appreciate that so very, very much. Hey, Ronnie, well, maybe I ought to check my Discord before I do anything else. No messages, no nothing. Okie dokie. Miss Ronnie, it is important for me to know if you received your package. Yes or no is all I need. Because I sent my boyfriend out to ship it because I can't get away during shipping hours. You know, that really sucks. I'm here in the office before the post office opens and I can't leave until after it closes. So I finally had someone able to go and do that for me. All right, I have a ton of things up here, y'all, that I need to talk about. We got some videos to watch. We got some stuff. Okay, I want to talk about the crash yesterday just real quick. Our sympathies go out to Spain and those who were connected. Oh, Mama Elizabeth. Yes, may the truth prevail. May the truth prevail. The helicopter crash yesterday, it happened. It was a Bell 206 sightseeing helicopter departed from Wall Street Heliport at 2:59 p.m. Thursday, flew south and then turned to fly north along the Manhattan shoreline up the Hudson River. At 3:08 p.m., the helicopter reached the George Washington Bridge, then made a turn to fly south along the New Jersey shoreline. Shortly after, the aircraft lost control and hit the water upside down just a few feet off the coast of the pier, the pier at Park Hoboken. Well, 3:17 p.m. 911 calls came in. Basically, the lovely family and couple, I'm going to share their picture with us. This is the lovely parents. They are not showing anything with children. This is a beautiful couple that lost their lives, and their children were ages 11 years and younger. There was a reported call in from the radio transmission from the plane helicopter that they were needing to return for gas, and then they did not do so. They should have been returned within 3 minutes. 20 minutes later, they had not returned. This is a devastating, even for the pilot. The pilot flying the helicopter, apparently, this most likely was not a pilot error as far as the ability to fly. If it was anything, was the ability to check and make sure that there was enough fuel. Even if there was enough fuel, something did happen in flight. The fuel could have been dumping. So we will wait for the investigations. We will make no assumptions at this point. But the sad thing is that a family that was celebrating the 40th birthday of the wife has been lost their lives in a celebratory helicopter touristic flight. It must, well, when watching late last night, it appears that the rear rudder propeller came off of the aircraft. When you zoom in, you can tell that you're missing the tail, the L section, or the part where the rotor is stuck to the rear rudder. And unfortunately, that was missing from the plane, and you could see it flying through the air and landing in the river. So there was a mechanical error. The helicopter did appear to be falling apart. Okay, so that said, our hearts and prayers go out to those families. Now, I want to come into something that is live right now in the, we're going to get to the Lori Daybell. There is some information I want us to watch on that. If you guys do not wish to watch the Lori Daybell information, please let me know. I will let you know when it comes up. But right now, I really want to come in. And if you have not seen this, y'all need to see this. Judge Boyd rips some attorneys a new one in in a case. I don't know what case this is that is being tried at this point in time. Let me remove the captions on this. Accused of unaliving Mark Anthony Saldivar in 2017 faces life in prison if found guilty. Trial that is happening currently, I don't know, may not be currently, in Judge Joe Boyd's courtroom, which I hope to go into this summer and spend a couple of days. You're here for the Daybell mockery. Great. I'm going to hit some. Hi, folks. We're all shocked and saddened in Spain. And by the way, Elena is from Spain. Apparently, the helicopter had technical problems before. If this proves to be true, someone should be accountable for this tragedy, and they will be held accountable for the tragedy. There possibly could be some criminal, but definitely there will be some civil follow through. The families can sue. I'm sure all that's going to happen. But truth be told, we are all more worried about the grief and the families that are affected as a whole. Okay. Judge Boyd is known for her no-nonsense way of running her court. She can be a very fair but very stern judge. I adore this woman. I so want to go sit in her court, and I'm going to this summer. But this was priceless, and we will be diving into it right now.
Filed a motion in limine. Since you were aware of.
Let me catch you up. I forgot. There was a motion in limine, basically an agreement between two sides of what evidence can and cannot come into trial. In that motion in limine, it was that the defense could not bring up issues pertaining to past behaviors, prosecutions, whatever, of whomever they're referring to. You're going to hear her say this again and again. And then on top of that, you're going to see two attorneys, one younger and one very much senior, and you're going to see some conflicts between them, especially when you pay attention to
State's motion in limine.
And here we go.
And I inform both parties, either side, if you have a motion in limine, before you enter into any territory that's the subject of the motion in limine, that you approach. And the reason why I do that is because, as both parties know, I do not know what the evidence is in your case. I don't know any facts of the case. I'm hearing this case as the jury is hearing it. And in the state's motion in limine, on page 2, it states, The state requests that the court grant this motion in limine and instruct the defense counsel to approach the bench and present the proposed evidence outside the presence of the jury before voir dire, opening statement, questioning, or in any matter bringing any witness or evidence of any of the following matters. And the number one thing says, any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. So, defense, it appears to the court that you violated the motion in limine unless you're going to try to tell the court that possession of child pornography is not a bad act.
Your Honor, what I'm trying to listen to the witness.
No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it.
He's all like, no. You're not going to talk. Shut it. Zip it. My court.
In regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm going to have the witness step down. And counsel, you'll take your client to the back. You're still under oath.
Okay, this was horrible. This witness fell apart on the stand. Fell apart.
And the rule has been invoked. And what I can
This broke my heart. She was almost hysterical.
tell you, unless you have some photos of child pornography that you're saying that the complainant had, then you're just throwing questions out and you're violating the motion in limine. It clearly states that you all are supposed to approach. Now, unless you all think that child pornography is not a bad act, then I don't know why that's a crime. Because if you're saying it's not a bad act, you asked this witness a question and it involved child pornography. Did I hear that incorrectly?
You heard that correctly, Your Honor, and I'd like to also make aware to the court yesterday when we approached about my motion in limine.
Sorry, I went and shut my door.
The court specifically regurgitated condition number 1 to defense in regards to the nude photos.
Your Honor, I understand that the court is of the opinion we violated the motion.
No, not of the opinion. You violated the motion in limine. The motion in limine says that you are to approach before questioning or in any matter bringing any witness or evidence of any of the following matters. Any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. And you're asking this witness about whether or not he had child pornography or something in his camera. The court considers that a bad act.
Your Honor, to be clear, the questioning of the witness is intended to establish whether or not she previously made these statements. They're not being offered under Rule 613 for their truth. They're being offered for what she said to another individual.
You are still, what you're questioning her about is a bad act that she said that was the bad act of the complainant. And that's a motion in limine. And you all should approach before you do that. You violated the motion. The court is finding that you violated the motion in limine. And the only question now is how is that corrected? Because nobody approached the court to say, I'm going to start asking questions that is related to number 1 to the state's motion in limine.
I understand the court's ruling. I've given my explanation for it. As far as the remedy is concerned, the court will do as it sees fit. I understand.
Oh, no, I am. But
Okay, he is trying to be humble a little bit. Okay, I may not agree with you, but I respect you and you do what you need to do. And I think he's ready to move on. Unlike what's going to happen in a minute. This old man, he needs to retire, dude. You're blowing it, dude. I'm just saying, this man stirs the pot, and the younger attorney is like, oh my gosh, I cannot believe you are saying this. Watch this. Now, this man's not super young, but he's young compared to the guy next to him.
you're still, it appears to court, acting as though you haven't violated number 1, and you have. You violated that motion in limine.
Your Honor,
And I can tell you, yes, counsel?
I think we're slightly, we understand the court's ruling. However, I do want the record to reflect, at least, that what we're asking is what the witness's previous statements. We are not accusing anybody of anything, and we're certainly not trying to accuse Mark, and we will be happy to explain to the jury.
It's still a violation of the motion in limine. Hypothetically, if somebody were to ask for any defendant, not just your defendant, if somebody were to ask a witness on the stand, hey, by the way, and didn't you tell somebody else that the defendant had possession of child pornography, the defense would be objecting because it's a violation of the motion in limine. It's a violation of the motion in limine in fact and in spirit.
Well,
Okay, so this particular elder attorney is arguing a dead point. And I'm surprised she didn't hold him in contempt because, boy, let me tell you, it's going to get nastier. She holds her temper well here. I have seen it where she has just shut them down, taken a break, come back in, but she holds it well. But it is a blatant violation in the motion in limine. And then this guy gets into it and starts trying to weasel. Well, what if we did this and what if we did that? Pay attention. His arguments are actually a mute point, and he starts arguing things that are not even being argued.
it is intended because this witness gave a number of prior statements. One to a police officer during an interrogation, which was video recorded. Another under oath before another judge in a different courtroom.
But here's the thing: it doesn't matter to the court. What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But instead, you have people who are violating rules, and I'm finding you violated the motion in limine rule. It's not supposed to be brought up until it's brought up to the court outside the presence of the jury. Now, what you have done is by bringing this up, I don't know if the jury's going to believe he was in possession of child pornography or not. I don't know if he was in possession of child pornography or not, because nothing has been presented to the court, and all you all had to do was approach the court and say, Your Honor, I believe we're going to go into number one of the state's motion in limine. And you know what I would have done? I would have had the jury step out, and I would have said, okay, what's the issue here? And you would have told me that, and I would have made a ruling.
I believe this came up yesterday.
No.
Yes.
Not the possession of child pornography.
The question of photographs on the camera
of nudes.
Right.
That's it, of nudes. And when we were here at the bench, I even told the state, okay, he has nude photos, allegedly. I said, how is that a bad act? Having a nude photo is not necessarily a bad act.
I see.
And both parties said, yes. Mr. Hunter, yes, Judge, you're right, it's not a bad act. And then we go a step further today, and now it's possession of child pornography.
She is in San Antonio, Texas. And Ronnie, maybe you and I ought to meet up there and go sit in the court view. Watch her for a while.
And I'm not going to allow you all to ask that question, and I'm going to instruct the jury to disregard.
We understand, Joe.
We understand. And there are some additional matters that she spoke of that have nothing to do with nudity or pornography. And
what would that be?
Here's where he goes offline.
Your Honor, I don't believe that any other bad acts or potential bad acts that Mark.
I think he is trying to save it and get him to shut up. And this person over here is like, I'm out. I ain't going to get in the middle of this mess. I do believe this younger attorney does try to save it, but man, it's not good.
Anthony Saldivar will be discussed other than those things which were discussed in opening statement related to the
I'll determine whether it comes in or not. And you know why I'm going to determine whether it comes in or not? Because there was a state's motion in limine that says any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, you're to approach beforehand. And I need to make a ruling on whether or not it's relevant and whether or not it should be admissible. That's me. That's my job.
I understand your...
So what other acts or what other bad acts that you feel, crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, that you feel this witness is going to be questioned about?
I can tell the court that it's going to be, and I don't know if there will be disputed or not, that he damaged the vehicle. I guess that could be considered a bad act. I want to...
Well, with regards to the damage of the vehicle, allegedly, it said that he put his foot through the glass of the vehicle. That's a part of this whole alleged offense and the offense date. So, counsel, you all know that if there's evidence that's going to come in that he damaged the windshield, that's already in through other people.
Right, and...
Okay, just FYI, we are now in 3 hours in the verdict watch for Sturmer. I got to keep them straight.
And the issue of what she said with respect to that to our client, she says that she didn't say anything. That she looked straight ahead, didn't look to the side.
All right, so here.
May I just finish?
We're getting off track. We're with the bad acts.
Well, I'm going to suggest that she has told people, and I believe if she said race just of the offense, if she said something other than what she told the police officer, I believe that's a prior inconsistent statement, or entitled to ask her about it. It has nothing to do with pornography, sex, anything else.
Counsel, I'm not challenging anyone on inconsistent statements.
Okay.
I'm not challenging anybody on that. The court knows the rules of evidence. What I am saying is there's a motion in limine. And I think it's safe to say for the people who have been practicing even a year that you know you're not supposed to violate motions in limine. And number two, if there's an alleged offense and videos have been shown in exhibits that it's alleged to be, or maybe the jury feels it's already been established that the person who kicked in a window or damaged the window of a vehicle is the complainant, because witnesses have said it's the complainant who did that. So you all know questioning the witness about that, that's really not about the motion in limine. The motion in limine is about your...
Okay, I'm going to stop here because there's some people here who don't know what motion in limine is, and I want to give the actual definition for that. A motion in limine is a pretrial motion that seeks the exclusion of specific evidence or an agreement from being presented during trial. It is made to the court before the jury has been selected in either a civil or criminal trial. The motion is decided by the judge outside the presence of a jury. Motion in limine asks the court to order the opposing party, its counsel, and witnesses not to talk about or even mention a specific fact or evidence in the presence of the hearing of the jury. Okay, so that's kind of what I said, but that's just the actual definition. That's right, Monica Sementilli verdict watch is now at 8 hours 39 minutes, and there you go. Well, now 40 minutes. Okay, here we go.
Our co-counsel,
you were so right,
violating it.
My able co-counsel, I can tell you if I can get 5 seconds, I believe he will go into next the matter of what was said that precipitated the fight. And I don't think it's about anything, and I think we're entitled to ask the witness.
Let me just tell you, you violated the motion in limine.
We got it.
You will not ask this witness any questions about child pornography on a camera unless you have
Catherine, that was Miss June.
We agree.
proof that there's child pornography on a camera.
Well, by the way, we do have proof of that, and it was a legitimate question. However, the court's ruled on it. That's not what I'm discussing. I'm talking about what we're going to do next. And while I can't look into his mind, I presume since the court has ruled on it, we can make a bill later, but we're not going to do anything in front of the jury. However, I do believe conversations, what she tells the police officer, what she tells the judge, if there's somebody that says you said something else, I believe that's fair game, that's impeachment. And all I don't want to do is, we shouldn't have to have the hearing like this before we ask every question.
No.
And if it doesn't involve child pornography or some extraneous offense, I think we're entitled.
No, you all have to have a hearing because it's a part of their motion in limine. You can't just.
It's not an offense.
And the last time I checked, possession of child pornography is an offense.
And we're going to be chastised, and the court's going to do something.
Oh no, my chastisement is just stating the law. There's a motion in limine in place, and the defense has violated. And I am not going to allow you to ask questions about child pornography.
We're not going to do that based on the court's ruling. However, we should be able to.
Your Honor, just in anticipation, the only other aspects of this questioning that I believe will venture into territory that the state might object to would be questioning about whether or not she had a hand in getting the gun into Mr. McIntyre's hands, if that is in fact what happened. And secondly, whether or not she is the source of the marijuana, which I'm not clear on.
All right, so here's the thing. And let me just tell you, this is what I'm going to say this.
She was asked that.
This is what I'm going to say, and I want you all to listen to me clearly. Both sides have been practicing law for more than 2 seconds. Everyone here knows that if you're asking questions, and those questions are related to what's already been brought in evidence, the marijuana, it's already in there. It's already in the evidence. Who had it, what they did with it. Yeah, you can ask questions about that.
And gun.
The gun. It's already there. But I don't want any deflections where people are pretending as though they don't know that they violated the motion in limine. So I'm bringing the jury back in, and I'm telling them to disregard the last question. I'm telling them to disregard any testimony or questions about child pornography. Does everyone understand?
Yes.
And the defense, you violated the motion in limine.
There you have it. She was not in a very good place on that. And I got to tell you, I'm with her on that. They knew darn well they opened up that line. They knew darn well what they were doing. And I felt that they over-argued it. And I am pretty sure, if I know anything about this woman, that she will pop up and discipline them in private in her chambers. Real quick, I do want to bring in and let y'all know I have opened up my phone lines. Lord willing, let me get the phone up. If you're going to call me, please let me know in advance that you're going to call me so I make sure that I don't ignore that said phone call, because I would love to have you call in if you wish. This is a comfortable, casual day, and I've decided to open up the phone lines for you guys. We are now pretty much 8 hours and 45 minutes in the verdict watch for Sementilli, and in 3 hours and 7 minutes in the verdict watch for Sturmer. Okay. Back to comments. I'm not sure the clock's right. I saw ticking after the jury was dismissed yesterday, but yeah. I know, honey. I know, Miss June. We got 2 Junes in here right now. Yay! Okay. So we have James Crumbley is asking for a new trial. And y'all, I have no idea what's going to go on in this, but I look forward to finding out. James Crumbley is the one who unalived a bunch of students.
permitted to participate by Zoom. The
Oh,
court
Gerald,
indicated that
if
there
you're
would
calling
be,
to come on
that we
live.
would make that request to the Michigan Department of Corrections. We also obviously have more ability.
Okay, here we go. And
Proceeding is being, as has been this court's practice in each hearing over the past 3.5 years, the proceeding is being conducted in person. In keeping with that procedure, we alerted all parties that defendant James Crumbley would be writted from the Michigan Department of Corrections. Ms. Sharon then indicated to my chambers that the defendant did not wish to be brought here for these proceedings, as is his right. Ms. Sharon also requested that her client be permitted to participate by Zoom. The court indicated that there would be that we would make that request to the Michigan Department of Corrections. We also obviously have more ability to control that at the Oakland County Jail. But we were unsure about whether the Michigan Department of Corrections would accommodate a Zoom hearing with the defendant that can potentially be lengthy. The Michigan Department of Corrections has accommodated that request to the extent that Mr. Crumbley will be able to see and hear these proceedings. And Ms. Sharon, I think you've indicated that Mr. Crumbley, although he has the right to be present for this hearing in the courtroom, that he's willing to waive that right to be present in court.
Absolutely, Your Honor. As the court has correctly indicated, it was our request that he appear via Zoom, so I would waive his appearance for purposes of this hearing.
All right, thank you. I wanted to indicate before we got started that I'm not in the habit of issuing late opinions. I tend to keep up with my responsibilities, so I wanted to let you know that I thought it would be appropriate to not issue an opinion on the remaining issue in the Jennifer Crumbley matter until hearing oral argument in this matter. So I will get back to you as soon as possible with regard to that.
Thank you.
All right. So I'm going to ask you to all please be mindful that I've read and thoroughly reviewed the motion filed by the defendant, the response filed by the Oakland County prosecutor, and the reply filed by the defendant. In fact, I read the entire guidepost report as well.
That's true, Ron.
I think it'd be helpful if we went issue by issue with Ms. Sharon giving her argument, the prosecutor responding, then Ms. Sharon providing any reply. All right, so Ms. Sharon, it's your motion. You can address each issue raised in your motion in any order you see fit. All right?
Your Honor, before I begin, when I typically argue in front of the Court of Appeals, I don't always touch on every issue that I've briefed, and I did not intend to do so today.
I'm so relieved.
I'm glad I could make your day, Your Honor.
Yeah.
So as long as that is acceptable to the court.
I have read
invited,
everything more than once
and
have pulled the cases and read the cases. So I think oral argument is important, but I would appreciate hitting the highlights. You did an outstanding job on your brief, and it is very detailed. But it is Friday, and I don't
Thank you so much
until 10 o'clock at night. So.
I understand, Your Honor. So I will proceed as I had planned.
Okay.
But of course, if the court has questions on any of the other issues, I'm always more than happy to answer those.
June, I worked with adults with dementia at a state hospital who committed horrendous crimes, and they were not able to withstand trial. So I understand where you're going. Blessings, my dear friend, and thank you for the hard work you do. Like you guys.
Again, Alona Sharon on behalf of Mr. Crumbley, Your Honor. Mr. Crumbley is entitled to a new trial for a number of reasons, the least of which is the concealed proffer agreements. And so, Your Honor, I want to start off this morning by talking about the court rule, the discovery rule that's at issue here, which is, of course, MCR 6.201B5. Your Honor, the prosecution would read the court rule so that the phrase, quote, for testimony modifies all terms of that subsection. So it would modify any plea agreement, grant of immunity, or other agreement. But the prosecution's suggested reading of the court rule does not comply with our rules of statutory interpretation, rules of grammar and punctuation, and perhaps most critically, Your Honor, it does not comply with the purpose of the court rule. First, Your Honor, the court rule is not ambiguous. The use of commas in B5 separates each clause such that the rule requires the prosecution to disclose any plea agreement, 1, 2, any grant of immunity, or 3, other agreement for testimony in connection with the case. But if Your Honor does find that the court rule is ambiguous, then it should look to the rule of the last antecedent. And under the rule of the last antecedent, Your Honor, the clause for testimony modifies other agreements.
I do see that. The jury has reached a verdict. By the way, if you said I liked, for some reason I have a glitch, it's only showing 2 of you. Redo your like again. Please put in I liked. We have 8 hours, 45 minutes, and 31 seconds, and there is a verdict in the Sementilli trial. Until they actually start coming into court, I'll go ahead and keep playing this. If you did I liked earlier in my live, everybody just redo it. There was a glitch. Oh, there we go. It's counting you now. So go ahead and redo it, whether you've done it once or not. Everybody put I liked to be in the drawing, but you got to like the live. Got to like the live. Okay. We will hop over as soon as I see people heading into court. In the meantime, we're listening to this Yahoo wanting a new tile.
Agreement, and not the first 2 phrases, plea agreement or grant of immunity. Under the rule of the last antecedent, Your Honor, and just general rules of punctuation, a comma would have to be inserted after or other agreement to reach the prosecution's reading. So essentially what the prosecution is asking Your Honor to do is read a comma into the rule that isn't there. And we're told by our case law that we presume the drafters of these rules are familiar with rules of punctuation and grammar, Your Honor. But the most compelling reason, Your Honor, that the prosecution's reading of the court rule must fail is because it's not supported by the purpose of the rule. MCR 6.201B5 is born out of Brady versus Maryland, Your Honor, 373 U.S. 83. That case requires the prosecutor to, quote, disclose any information that would materially affect the credibility of his witness. In People versus Atkins, 397 Mich. 163, our Supreme Court stressed that the focus of requiring disclosure in such situations is to reveal factors that the jury may consider in weighing a witness's testimony and which may motivate the witness to give certain testimony.
Well, let me ask you this.
Yes.
I don't want to mess with your mojo because you're sort of on a roll
Don't
here,
worry.
but
I've got more mojo than I can handle right now.
So what if I agree that the prosecutor violated the rules with regard to discovery? What if I agree with that?
So where does that take us next?
Yeah. So,
Sure.
So you're telling me about a Brady violation, but
No.
what is the remedy? What is the remedy if there's a violation of the rules of discovery? Just plain old 6.201B2.
Sure, Your Honor. And I will answer that question in 10 seconds.
Okay.
I do just want to point out, because I feel like when the other defendant's case was argued, there was this sort of conflating of discovery violation versus Brady violation.
They're separate.
But okay, and I believe that Your Honor understood that concept. I just didn't feel like it was super clear on the record. So right now, I'm addressing the discovery violation. So as to your question of what is the remedy, right? What is the sanction?
Well, because then you started telling me about Brady, so I agree with you that they're separate.
So, Your Honor, I referenced Brady because 6.201B5 is drafted in the spirit of Brady. It is drafted in the spirit of protecting a defendant's right under Brady, but they are 2 different claims.
Okay.
As to the sanction or the remedy, Your Honor, so we look to 6201J, right, that talks about violations. And under the court rule, as well as the applicable case law that's cited in the brief, Your Honor has wide discretion to grant an appropriate remedy or sanction. And Your Honor should be guided by a variety of considerations. First, if you just look at the plain language of 6201J, it lists several examples of remedies that Your Honor could use, except none of those would be helpful in this case because the prosecutor didn't disclose until following conviction. So then you keep reading, or enter such other order as it deems just under the circumstances.
And you're saying that would be a whole new trial?
Absolutely, Your Honor, because it is the only way to make Mr. Crumbley whole. It is the only way to correct the violation of the court rule. If someone could suggest to me some other sanction that could remedy this wrong, I'm happy to hear it, but there isn't one, right? And that's why the prosecution has to keep hounding this argument that they didn't have to disclose this immunity proffer agreement, Your Honor. Your Honor, I guess I would ask you, if you are at the point where you feel like this was a violation of the discovery rule.
I likely do.
Okay. I can take the message that Your Honor is telegraphing, Your Honor. I do want to remind the court that back on January 31st, when Jennifer Crumbley's case was being argued, Mark Keast argued to this court that his office did not have authority to grant immunity outside of statutory immunity. That's a direct quote. The only way to grant immunity is to petition the court. It now seems
You're talking about oral argument on Mrs. Crumbley's motion.
Yes, Your Honor.
Okay.
And I do cite to it, I believe in the brief.
Oh, yeah, you're talking about this year, you're not talking about the trial. Yeah.
Correct,
Okay.
Your Honor.
All right.
So it's remarkable, and it should be remarkable to this court, that it appears at this point in time they've abandoned that argument, Your Honor. It's nowhere in their response brief. I don't know what Mr. Keast will argue today, but they absolutely do have the authority to bestow immunity outside of statutory immunity, and that is what this argument was. So to go back, Your Honor, to the remedy, I do want to talk a little bit more about that. According to our case law, when Your Honor determines the appropriate remedy for a discovery violation, you must consider and balance the interests of the courts, the public, and the parties in light of all the circumstances, including the reasons for noncompliance. Your Honor.
Okay, I need to hop in. We got people coming in and out. I want to let you know what we're doing. Right now, we are listening to a motion hearing for dismiss or retrial because of not disclosing an agreement between the state and the witness, and Crumbley is not present in court. We do have a verdict in the Sementilli trial. We are waiting for them to return to court. As soon as I see motion in the court, we will hop on over. This is just hit this morning. You can see their clock is 9:31:32 a.m. their time. We are watching it a little late, but this is very important because the Crumbleys, both parents, were charged with oh gosh, I can't remember what they were charged with. Something like what was it, manslaughter? Because their son went to a school and unalived some people and harmed people, and they bought him the weapons that were used. They knew he had mental instability, and they went ahead and got him weapons and took him to a range, and they thought that was a safe activity for him. Well, apparently not. So anyway, this trial became a precedent in the fact that they are the first parents to ever be held responsible for their child gaining access to a weapon and unaliving students in the school and harming staff, students, and the like. So this case has set a precedence across the entire country, and now they're arguing for a new trial.
Honor's paramount interest is that the discovery should facilitate the search for the truth. The public's interest, Your Honor, is that when a trial concludes, it can have...
Hey guys, we have movement. I told you we go back, and here we go. We have a verdict in the Sementilli trial. Now I have to change my header. Oh, verdict watch. I got to change it. Oh, no, you didn't do that. I'm taking out Sementilli because we have a verdict in the Sementilli. All right, when they come back in, we'll go back over. In the meantime, let's go back over here.
Have faith in the outcome of the trial, and obviously a party's interest is that it be able to properly prepare for trial. And the court should also consider whether the objecting party was surprised. Every single person in this courtroom, with the exception of 4 people, were surprised, Your Honor, by the existence of these proffer agreements. In People versus Taylor, 159 Mishap 468, the court instructed that the first question for Your Honor to answer when fashioning a remedy is whether the party's interest in preparing his own case or his opportunity to test the authenticity of a witness or the authenticity of evidence has been prejudiced, which it has been here, Your Honor.
Can I ask, I want to ask you about Taylor, but
Yeah.
can I ask you what kind of immunity you say that they conferred? Because it's not transactional, right? And with regard to use immunity, doesn't use immunity protect a witness against compelled testimony? There was no testimony compelled by either Ejack or Hopkins. I think your brief says pocket immunity. I don't know. So what flavor are you alleging of immunity?
I don't know, Your Honor, that there has to be a specific title to the type of immunity, but the case law is cited in the brief that references, right, pocket immunity is one of the phrases, informal immunity, but the case law is clear that where a promise is made in exchange, even just for cooperation, that is a form of immunity, Your Honor. And here, obviously, the plain language of the proffer agreement promised Hopkins and Ejack that any evidence or information that was provided to the prosecution during these proffer meetings could not be used against them in the prosecution's case in chief.
Okay.
So that is, I do agree. I guess I respectfully disagree that it's not use immunity, but even if you don't want to give it that proper title, it certainly is a form of pocket or informal immunity, which would still be required to be disclosed under Brady and under the court rule, Your Honor.
Okay. Yeah, but I don't know. I think use immunity is when the testimony is compelled. Ejack and Hopkins still don't have to testify, right?
No, they certainly were not required. I mean, they were subpoenaed. Mr. Keese indicated that at the last hearing. So obviously they were required to appear, but I think everyone agrees that they probably could have asserted the Fifth Amendment.
They probably would have.
Correct, Your Honor. The second consideration under Taylor is that what remedy may be appropriate giving due regard to the competing interests of the party, the court, and the public. And Your Honor, I want to take a moment here to address the Dickinson case that's relied on by the prosecution in its response, because the procedural facts of Dickinson are very different here. So in Dickinson, we have admittedly a discovery violation that comes to light during the trial. And instead of asking for a sanction under the court rule, the defense counsel in Dickinson simply moved for a mistrial, which is a different claim. And the review of the Court of Appeals in Dickinson is a review of a trial court's authority to grant a mistrial and whether the granting of a mistrial is appropriate. That is a different set of law. That is a different analysis. So Dickinson is really wholly inapplicable to the case that's before Your Honor today.
Well, you mentioned Taylor, but in Taylor, U.S. Supreme Court case, the Supreme Court affirmed the trial judge's exclusion of a defense witness not included in discovery, and there was some other
I was just going to get to that case.
That happened.
Yes.
Right, but that was kind of the easy button there, right? Because it was that witness was going to commit perjury. There was some underhandedness, and the witness wasn't disclosed at all, right? And the witness was going to perjure himself. In this instance, we don't have a witness that's undisclosed, right?
Correct.
Ejack and Hopkins were on the witness list from the beginning. They testified at the preliminary examination, right? So Taylor's a different scenario, isn't it?
Your Honor, and I don't use Taylor for the purpose of the facts being necessarily on point, but what the case stands for. May I address that?
Sure, go ahead.
Okay. So, and Your Honor has touched on this a little bit, but just to kind of reiterate the basic facts in Taylor, the defendant, defense counsel at the first day of trial moved to amend his witness list to include 2 witnesses, one of which he said was much more critical than the other, and reason that he didn't provide the name in a timely fashion and pursuant to the discovery order was because he had trouble locating him, so he didn't have an address, and that the witness had seen the entire incident from which the criminal charges stemmed.
And both of those things were lies.
Correct. That is correct, Your Honor. So the judge tells the lawyer, bring your witness in tomorrow, I'm going to make inquiry, and I'll make a decision. But what is remarkable in Taylor, Your Honor, is that you have a defendant who has a constitutional right, a due process right to present a defense, a constitutional right under the compulsory process clause to present evidence that is favorable to him. And despite those guarantees under the United States Constitution, the United States Supreme Court affirmed an incredibly severe sanction, Your Honor. Incredibly severe, okay? So what do we take away from Taylor? If the violation is intentional, okay, if there is bad faith behind the violation for the purpose of gaining a tactical advantage, a severe sanction is warranted. That's what we take away from Taylor. And Taylor said that the court can consider whether compliance with the discovery rule is onerous or relatively simple. Your Honor, Mr. Keese provided discovery to defense counsel 34 times. 34 times subsequent to the signing of these proffer agreements. On 34 separate occasions, he consciously decided to continue to conceal these proffer agreements that he was required to disclose under Brady and under the court rule. It was intentional, it was willful, and despite the fact that I frequently forget to attach things to my emails, it was an easy thing to comply with. It would have taken 5 seconds, Your Honor, but he didn't do it. So because the violation is intentional here and willful, it is deserving of the harshest sanction. But Mr. Crumbley isn't seeking the harshest sanction, Your Honor. He is seeking the one and only sanction that can right the wrong, that can make him whole, and that is a new trial, Your Honor. Anything short of that, and there is no correction to the misconduct, Your Honor. So again, the court is to consider the reason for the failure. So what does the prosecutor's office argue? One, they first argue that it's something that they didn't have to disclose. I really hope by now the court is not taken by that argument. The second reason that they initially argued was that it was never an immunity agreement because they can't bestow immunity, which, Your Honor, the case law cited in my initial brief clearly dispels that argument. The reasons put forth by the prosecutor are incredible, and they should not persuade this court to conclude that the misconduct was unintentional. Your Honor, the prosecution team consists of 83 years of legal experience. Karen McDonald, 26 years, and a former judge. Mark Keese, 19 years. Dave Williams, 29 years. Joseph Shada, just under 10 years. 83 years of legal experience, Your Honor. Your Honor cannot really believe that 83 years of experience and this team did not know that they could bestow immunity on Hopkins and Ejak, that those agreements in fact bestowed immunity and that they were required to disclose them. Your Honor, I want to turn now to the prejudice issue. So if you look at Davy, which is companion, it's Davy and Obispo. So they have an evidentiary hearing in that case when the, do you have a question?
No, it's incredible to me and Davey that the defense attorneys had to go to the Detroit Police Department to get their discovery.
I don't know that that's so unusual, frankly.
Well, no, but I mean, completely. It seemed dark ages.
Oh, you mean that they didn't receive it via email?
Or, no, not email, just, I don't know.
Well, Your Honor,
I'm sure you called the Detroit Police Department,
so to turn to the prejudice,
there was no discovery there, though. No, zero. None.
That is correct.
Right.
But if you look at Davy, Your Honor,
It's prejudice, capital P, right?
I don't know what you mean by that.
Well, they weren't given any discovery.
Correct, but the court in Davy, never makes a finding that the failure to produce the discovery was outcome determinative. All it does is the trial court took testimony from trial counsel who testified that.
Okay, guys, we got verdict. Here we go. The jury has reached a verdict. The court is starting to convene. Just so people know, we do have several things in queue for today while we're waiting. I wanted to play this motion for the Crumbley trial. We also have the Menendez brothers, 10 o'clock California time, 12 o'clock our time, supposedly. But I do have a live feed. I am waiting for them to go live. If somebody else has a better feed, let me know. But that is playing. I have multiple things in queue for us. Okay. All righty. Let's get into this and get the volume up. The volume is up. We're waiting on the court. Why do we not have volume? Why do we not have volume? We got to have volume. I'm going to look for a different feed just in case. No volume. Okay. I've got two feeds up just in case we got no volume. The court has reached a verdict. The jury has, not the court. We are waiting. I guess they're waiting for the judge. Okay, guys, real quick. Busy. Yes. Thank you so much, Toxic, everybody. When we're watching court and you want to know the details, go to Discord. Our fabulous partners in crime that I absolutely adore them. They are amazing. Go to Discord, go to As the Gavel Drops. As the Gavel Drops has all your court document needs. Please log in, register your account, log in, then validate your account. Once you validate your account, you too can have access to all the fabulous court documents that we have. As always, As the Gavel Drops is the #1 place to go for court document needs. Also, please, if you are using their stuff, make sure that you give them credit where credit is due. They're coming in. Also, while we're waiting on that.
Jury and all present. Good morning. Juror number 10, I understand the jury has reached verdicts. Is that correct? Are the verdicts dated and signed?
Yes, sir.
Please hand all verdict forms to the bailiff. Thank you.
This is going to be very case for her and the victim.
This time, the clerk, please read the verdicts.
Yes, I hope so.
In the Superior Court of the State of California, County of Los Angeles, in Department 101, the people of the State of California versus Monica Sementilli, in case number BA 452-97502.
Maybe we'll see real clear.
We, the jury, in the above entitled action, find the defendant, Monica Sementilli, guilty of the crime of murder in violation of Penal Code Section 187A. A felony is charged in count 1 of the indictment. We further find the murder to be of the first degree. We further find the allegation that the murder of Fabio Sementilli was intentional and carried out by the defendant, Monica Sementilli, for financial gain within the meaning of Penal Code Section 190.2A1 to be true. We further find the allegation that the defendant, Monica Sementilli, intentionally killed the victim by means of lying in wait within the meaning of Penal Code Section 190.2A15 to be true. Dated April 11th, 2025, juror seat number 10, 4-person. In the same case, title, and cause, we, the jury, in the above entitled action, find the defendant, Monica Sementilli, guilty of the crime of conspiracy to commit murder in violation of Penal Code Section 182A1. A felony is charged in count 2 of the indictment. Dated April 11th, 2025, Juror number 10, foreperson. Ladies and gentlemen of the jury, are these your verdicts? So say you one, so say you all.
Please poll the jury.
Ladies and gentlemen of the jury, as I call your seat number, please answer yes or no to the question. Juror in seat number 1, are these your verdicts?
Yes.
Juror in seat number 2?
Yes.
Juror in seat number 3?
Yes.
Juror in seat number 4?
Yes.
Juror in seat number 5?
Yes.
Juror in seat number 6?
Yes.
Juror in seat number 7?
Yes.
Juror in seat number 8?
Yes.
Juror in seat number 9?
Yes.
Juror in seat number 10?
Yes.
Juror in seat number 11?
Yes.
And juror in seat number 12.
Yes. The jury has been polled. The verdicts are ordered recorded. Both sides waive reading of the verdicts as recorded by the people
Yes.
and the defense.
Yes.
Your service now comes to an end. A couple things I need to tell you. First is my thanks. You made a tremendous sacrifice. We've been together for a long time. You are the backbone of this democracy, and for that you have my endearing thanks. Next, the admonition I've given you many times is now lifted. You are free to discuss this case with anyone you so choose. You don't have to talk to anybody if you don't want to. This is up to you. The lawyers may want to talk to you. It's up to you whether you want to talk to the lawyers. If there is any misconduct, by the way, anyone approaches you, I want to hear about it. Next, all identifying information about yourselves is ordered sealed. It cannot be unsealed without an order by me, which I cannot do without notice to you. I hope your service before me wasn't too unpleasant, because I'm going to see you again soon. You're now discharged. The jury assembly will sign out. Thank you so much. Make room for the jury.
Woo! Y'all, what? Oh, man. That was dramatic. Well, that's right. What did she think? And lying in wait. That lying in wait was a part of the red room first degree. Thank you, John. I was just getting ready to type all that up. Thank you so much. You are always on it for me, and I can't thank you enough. Yes, Monica Sementilli is going away for a very, 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 very long time. Now the judge gets to decide her fate. Wow. Monica Sementilli.
The jury also now at the courtroom. Mr. Lean, when you should have sentencing.
Could we request a date from the end of June?
Yes. That's a good date. Any days good? I'm waiting for a good date.
Sorry. G26, Your Honor?
How's that with the people?
May I have a moment?
Sure.
Did you say the 26th, counsel?
Yes.
Do we have a time for June?
Is it possible to do it on a Monday or a Tuesday?
24th?
Judge, we have an evidentiary hearing on the 24th. We have a evidentiary hearing on the 24th.
23rd, Your Honor, would be fine.
Yeah, the 23rd would be better. Is that with us?
Better.
How's the 23rd?
Good.
Does that agree with you, ma'am? Now, can you present sentencing June 23, 2025, 8:30 a.m. in this court? That's remand without.
Yes. We told him.
Okay, I got her there. I got her on the schedule. That was quick and easy. Oh, let's watch. Let's enjoy. She'll be sentenced on June 23rd at 8:30 in the morning, their time, which is 9:30 our time. Thank you, Jesus. Thank you. It's not like 7:38 East Coast time. Come on, ma'am, stand up, but make it easy. He's like, stand up, let's go. You're gone. You're gone. Keep going. Nope, 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 no talking. Bye-bye. Well, at least she doesn't have to do the fingerprint. Gerald said, my question to her was it worth it? Yeah. Was it worth it? Okay, we are now in 3 hours and 43 minutes in the Sturmer trial. You guys, we did it. We did it. That's right. You're not accused anymore, madame. You were guilty of 2. You were guilty of murder in the first degree with lying in wait, and you were guilty of conspiracy to commit murder. Therefore, hello, bye-bye. You'll be enjoying the Britney Spears song for a while. So, no more actual escapades in the holding cell of the courtroom between you and Baker. So this was definitely justice for Fabio Sementilli and his family, and we do continue to give our condolences to them because this is a very difficult thing, and I really, really, no matter how much we celebrate, her guilt, we do have to remember. Oh, don't want to do that yet. We're going to share this. We do need to remember that someone has passed away and that there's a family that is now going to have the opportunity to finish their grieving and hopefully be able to move forward from here. We also have to remember that there were children of hers that are involved, and one of the children, the daughter, believes her mother is innocent. This is going to be very impactful and difficult for her as well. So it is not an easy thing to go through. I've been through it. I lost a husband to prison, and it wasn't until a long time after prison I made my mind up whether he was innocent or guilty. But I continually commented until I see evidence to show he's guilty, he's innocent. I understand that position where the daughter is. Hopefully, we won't have to hear any more about their eardoms and fun times ever again. No more phone X calls we'll be having to deal with. Oh, God, thank you. That was hell. I don't want to hear those calls again. Yeah. Well, she's going to have to do a lot of acting in her future to be able to get along with all those women. Who knows? She may become I can't say this legally on thing, but she may flip. If she is that kind of manipulative woman, she may flip. So we'll see. So now we are going to go to the James Crumbley hearing. Now, James Crumbley is the father of Ethan Crumbley, who unalived some students and teachers at a school, harmed some people, and James is requesting a new trial due to the fact that there was evidence that was withheld, and that was agreement between a witness and the state, and he is seeking a new trial. Y'all, we get a new trial on this, it's going to be amazing. I am seeing a little bit of shaking on the camera for Sturmer. Doesn't mean anything really, but I am keeping an eye out. Please, everybody who's watching, even if you're watching in another program, please comment I liked to be entered into a drawing. Hop on over to, there we go. Thank you, Facebook. Go over to the, hop on over into YouTube if you wish to participate. And then you can hop back over into what other format you're watching. Currently, I am streaming on X as Alternate Jurors, of course, here under Ada K, Facebook Ada K, and Instagram. So thank you so much, David, for liking. So pleased with the verdict. I hope Fabia's family can find some peace. You know what? I have to say, I don't know if peace will ever be found, but I think they can find a way to move forward. it is so hard to find peace with something like this. It's just unbelievable. Hello, amiga. So we are going to go over here into the Crumbleys. We're going to finish this. Then I've got some stuff for the Lori Dayville. I got a Q thing, and then we also have the court hearing for the Menendez brothers that's due to start. I am seeking for a live feed. I have a live feed outside. The latest news updates is that there was a lottery held. Why am I doing that? There was a lottery held for people to get into the courtroom. That has been done. And now I'm waiting. Mods, if you find a live link on that I don't have, please let me know. But right now, this is all that I have. That's all that I got. That's the only live feed I can find at this moment, but I am working on it. So in the meantime, we're going to go back over here to the Crumbley motion hearing and finish this, and then we'll go on. Right now, we also have the Sturmer trial. Last time is 3 hours and 50 minutes in the Sturmer trial. Yes, the Sturmer trial. No more Sementilli. We're done.
Prepare was compromised, and that was enough prejudice. That is the prejudice that is required, Your Honor, under the discovery claim. And so let's talk about the prejudice in this case, Your Honor. James Crumbley was prejudiced because he was unable to effectively cross-examine the witnesses as to their bias and motive. He was unable to fully prepare his case. But perhaps what's most compelling, Your Honor, is that I reference in the reply brief the audio from Mr. Hopkins' initial interview, right?
I listened to it.
The day of the shooting. Mm-hmm. When you listen to that audio and compare it to the testimony that he provides at trial, subsequent to the proffer agreements, there are distinct differences, Your Honor. Nothing in his interview to the police expresses frustration with the Crumbleys' unwillingness to take their son home. There is no mention that they refused to take EC home because they needed to return to work. He explicitly says, Your Honor, in that audio, the parents were absolutely on board to get him help within 48 hours. And he also tells the officer, look, these parents, they know that their son has a tremendous amount of anxiety when it comes to missing class. So much so that he tells the officer that James Crumbley told him he wanted to plan a family vacation and EC was going to have to miss class for it, and told his dad, I don't want to go on the vacation. I cannot. Right, within hours, okay, of the shooting, where he does not express any frustration with the Crumbleys, any concern about James Crumbley that he is disinterested, that this meeting ends abruptly. And when you compare, Your Honor, those statements to the officer shortly after the shooting and his testimony, where he talks about the meeting ending abruptly, the parents not acting appropriately with EC, and I detail it all in the brief, I don't think I need to repeat it. But not disclosing the proffer agreements, Your Honor, it robbed him of the inference that this gentleman's testimony shifted as a result of the proffer agreements, Your Honor.
Okay, well, this meeting was 12 minutes long, right?
I believe it was 20, but 12.
Mm-hmm.
Yes. But the officer asked him repeatedly about the meeting, about the parents. How was the child doing? Were they willing to get treatment for their son? And Mr. Hopkins expressed no concern about the parents, not one shred of concern, not one observation in that interview about their conduct during that meeting, about their attitude during that meeting.
Enjoy your walk, June.
Your Honor, we know that without the proffer agreements, Hopkins and EJAC would not have testified.
Sorry, guys. I'm going to take a quick comfort break. I'll be right back.
That is a reasonable inference given their lack of cooperation with the Guidepost investigation. They had no interest in transparency, and their interest was self-preservation.
Okay, but the prosecutor would say that their everybody's interest is self-preservation, right? So they were incentivized to shine themselves up before the proffer agreement, during the proffer agreement, and after the proffer agreement. No one, everybody, any reasonable person avoids being charged with a crime, right?
100%, but not every person is a witness in a criminal trial. That's what matters here, right? What gives them the bias and the motive to have that shift, in the way he characterizes his interaction with James's interaction with EC, their willingness to get this child help. Here's the distinction, Your Honor.
He talks about it when he's being interviewed by Joe Bryan at the jail too, right? There's an interview with Joe Bryan at the jail.
Between
Mr. and Mrs.
and the child.
And the two defendants. And a lot of those things are stated there.
Are you talking about the exhibit that's attached?
It's exhibit 2.
Yes, Your Honor. I reviewed that twice. There is nowhere in that interview where the Crumbleys indicated that they had to leave to go to work. That is not in there. There is nothing in there.
They do leave to go to work, right?
Your Honor, the point is that the prosecution tries, but the reason that they leave, Your Honor, and they leave EC at school, in that initial interview with Hopkins, he makes clear that those parents wanted EC to stay in school, Your Honor, because they had serious concerns about the amount of anxiety he experienced from missing class. And that's confirmed by Hopkins. He talks about in great detail how much the students have struggled because of COVID, and that EC seemed to struggle a lot from not being in school. His grades had declined a bit from that, and his parents confirmed that not being in class was incredibly anxiety-inducing for him.
Wasn't he sleeping in class at some point?
I believe that is a statement that he might have made to the CFP, and a teacher might have reported it.
That's fine.
But regardless of that, I don't think it's disputed that EC reported and his parents acknowledged that not being in school was incredibly difficult for him, and that he wanted to stay in class. So you go from Mr. Hopkins telling the officer these parents were on board, they wanted to keep him in school because they knew he would be upset if they took him out of school, to this shifting narrative at trial that no, they didn't want to take him because they didn't want to be bothered and they didn't really think he needed help, and so on and so forth. That is a remarkable shift in the characterization and the narrative of the Crumbleys, specifically James Crumbley and his conduct in that meeting, Your Honor.
Okay, but regardless, that doesn't change. Whatever EJAC and Hopkins say doesn't change the facts. That doesn't change what happened. The parents came there. There's texts, there's videos, there's all kinds of things that happened before and after.
Your Honor, I don't dispute for one moment. They came there.
She didn't want to come at first, Mrs., right? And said she couldn't miss work, and then she comes, then they're there 12 minutes, they leave without him. Like, nothing EJAC and Hopkins.
Okay, guys, we do have some movement in the courtroom with the Sturmer trial. I do not see some people's clocks counting down anymore. If anybody else has an idea of the time, that would be great. But right now, there is something going on in the Sturmer trial. I will bring you on as soon as I have a feed other than the seal. You know, this is all we got right now. So I'll bring you on when we have something more than that. All right, back to this.
Changes that.
Your Honor, the facts might not change, but the way that they're characterized and the narrative that's given around the facts, right, that's what's important. And that's what the prosecution used Hopkins for, in part, was to give testimony about how they conducted themselves in that meeting. The fact that they seemed almost irritated about having to be there. The fact that the meeting, quote, ended abruptly. And then this assertion that they really didn't seem to think getting help for him was important, which is the total opposite of what he says in that meeting immediately after the shooting. His exact phrase was, they were on board. That's it. So how do we go from there to portraying these parents as not caring, not knowing their son? It's just, they don't coincide, Your Honor. They are distinctly different.
Well, she
And,
wasn't going to come at first, right? She said call the dad.
Your Honor, she's not my client.
Oh, I know she's not your client.
Mr. Crumbley
But you
is.
said the parents, so.
I apologize.
Yeah.
But when you look
We're
at
4 hours-
globally his statements,
So we're 4 hours into deliberation in the Linda Sturmer trial.
to be fair, I mean, he talks mostly generally, right, about mom and dad. You know, he tells him, no, they came to the school, we had this meeting. He even talks about them telling him about the grandmother passing away, about the loss of a dog, about the friend moving away, so on and so forth. So there is this exchange of information, and there's never a characterization at that time that they're somehow inappropriate.
Well, they're going to say there wasn't an exchange of information.
Well, I understand that that's what they say, except that Mr. Hopkins' interview says otherwise.
No, prosecution's going to say there wasn't an exchange of information. If there was an exchange of information, the prosecution's going to say this wouldn't have happened if there was an exchange of information.
Your Honor, at that moment in time, Jack Hopkins, James Crumbley had no reason to believe, and this kind of dovetails into the legal duty argument, that EC was had a propensity for violent acts. Okay, under the law, and I yes.
What about that picture?
Yeah.
They had the picture before they came to the meeting, right?
100%, Your Honor.
Yeah.
Your Honor, children draw pictures of things. It doesn't mean, if every person who drew a picture meant that that was their intention going forward. I mean, people, I don't want to call it a doodle because I don't want to undermine the significance of it. But to suggest that because he drew a picture and has never had a history of violence that his parents knew of, specifically his father, it wasn't foreseeable. It simply wasn't. I mean, when you look at Hopkins, he saw the same picture. But what did he say? What did he tell the officer? This kid's never been in trouble. I barely know him because he's never been in trouble. He comes to school, his attendance is solid, he's never got into fights, he's never been suspended. Why is that? Because he's never doing anything wrong. You're taking a kid who has no history of behavioral problems, of misconduct in school, and
There was a phone call the day before there was a phone call, they both were aware of the phone call the day before.
I don't know that
about
there's
researching bullets.
Right. And Your Honor, I don't dispute that that happened, but the fact that someone researches bullets, no one disputes that this was a hobby of his. It was a hobby that he enjoyed and that he did with his parents. And in some communities, that's a totally normal hobby for a 15-year-old child to have with his parents. And I think the testimony at trial very much confirms that in this community, that is nothing unusual, Your Honor. But when you look at the narrative that's put forth and how it shifts, James Crumbley did not have the ability to cross-examine these witnesses about why their testimony shifted, why the information that they gave shifted. And it would have been a reasonable argument and a reasonable attack on their credibility, Your Honor, to point to the proffer agreements for the reason in that shift. But again, Your Honor, even under Davey, the prejudice prong is whether or not the defendant's ability to prepare the case has been hampered, right? And that's exactly what you have here. That meeting and their alleged conduct and disinterest in that meeting was a huge part of the prosecution's case.
Okay, so you're talking about materiality. Do you want me to let the prosecution respond, or?
It's your courtroom, Your Honor. Whatever's easiest for Your Honor.
Well, I think it'd be best to issue up by issue. I guess I should presume that you're done talking about this part.
About the proffer?
Yeah, I
am.
Okay, well, I'm going to let them respond, and then I'll let you reply.
Thank
you.
Thank you, Judge. I think the court, some of the court's questions, I think, correctly exemplify part of our argument, and that is the amount of evidence that was presented to the jury that is both uncontested and proved at trial that showed, irrespective of these witnesses, the guilt of the Crumbleys.
Okay, but you're jumping to the end. Mr. Keese, you agree that a prosecutor is under duty to disclose any information that would materially affect the credibility of a witness?
Yes, Judge. Brady
If
obligation,
I had
of course.
$1 for every time I
Yes,
said
sir.
credibility is always
I
at
mean,
issue, I
ma'am.
could retire right now.
Yes.
Right? Credibility is always at issue, right? And so wasn't the defense deprived of a robust cross-examination?
No, Judge, and I do want to point out that the interview that counsel is referring to, that was turned over to defense. Defense counsel had that
Are you
in the first...
talking about the audio tape she sent me, or Exhibit 2 to your brief?
The interview of Mr. Hopkins from November the 30th of 2021, along with the narrative statement summarizing that.
Sure.
So counsel had opportunities, if counsel sought at trial, to try to cross-examine on any inconsistencies. I don't believe there to be any material inconsistencies, and I'll get to that, Judge. I do want to highlight just a few things. I want the court to recall that the evidence showed that it was approximately 1:10 p.m. on the afternoon of November the 30th, 2021, when the active shooter alert went out to parents of Oxford High School students. Those parents raced to the high school in hopes that their children were unharmed and alive. But James Crumbley didn't. He went home, He went home to look for the gun that he bought his son just 4 days before. He went home because he knew his son was the shooter. James Crumbley is the person who bought the murder weapon. He's the person who didn't lock it up, even though he was given the cable lock, an easy way to do so. James Crumbley knew his son had lost his only friend just the month prior. James Crumbley knew that his son's only hobby at this point was going to the gun range, and that his son had voiced signs of mental distress months prior. It was James Crumbley who wrote to his wife, "My God, WTF," when he was shown that math worksheet. This series of choices that I've just outlined led directly to the deaths of Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. And those series of choices had absolutely nothing to do with Ejack or Hopkins. But not only that, I dispute that the crux of the testimony of Hopkins and Ejack was not uncontested, because it was uncontested. No dispute that Hopkins called the parents to the school. No dispute that math worksheet was sent to both of them. He provided a list of mental health resources to the defendants at that meeting. We know that because that's on video. He said he wanted them to get their son help that day if possible. He never testified, and he never told anybody that he had threatened to call the school resource officer or the police. It's uncontested the length of the meeting. We know that because it's on video. We know the shooter went back to class. We know that no discipline was handed out. We also know that neither Hopkins nor Ejack voiced that they thought at that time that the shooter was a threat to anyone else but himself. That uncontested evidence was used in part by the defendant to try to cross-examine those witnesses. This isn't testimony used to stretch or to impress the prosecution. That was just what happened. This is not evidence of somebody who was trying to curry favor with the prosecution judge. And that's important because ultimately, if the court has already made this decision on discovery violation, ultimately the decision is remedied. I don't think you should, and I would like to go through that discovery violation briefly if I may. Okay. As much as I believe that our position is correct and the law is clear, I don't want to leave the court with the impression that there was an effort to hide evidence or gain an unfair advantage. I understand and appreciate the knee-jerk reaction that occurs when it's learned that a proffer agreement wasn't disclosed in discovery. I've done dozens of them. I've petitioned the court for immunity dozens of times. So I understand that knee-jerk reaction. When a co-defendant flips, they proffer, they're given a plea agreement, and they provide testimony, that always goes to the co-defendant. Always. The same as someone is given immunity to testify. And the court correctly identified this. We petitioned the court for immunity to compel testimony. That's what use immunity is, Judge. And whether or not there is some sort of other name for immunity out there, that is not what was included in the proffer agreements.
Well, I think what Mr. Rohn said is they got something.
They got the opportunity to tell us what happened in the first meeting and first meeting only, with a promise that we wouldn't use what they would say to us should they be charged later on.
Well, there's an incentive there, right?
Judge, to the extent that they had any incentive to tell us what they wanted to or tell the police, that would have existed irrespective of the proffer agreement or not. They were sued in, I think, 1 week after the shooting. Multiple lawsuits, they're sued personally. That was not a secret. The civil depositions occurred post-exam, pre-trial. Trial counsel had copies of the depositions. Sean Hopkins testified 4 times. Nick Ejack testified 3 times, each without protection.
Are they testified before the proffer in the civil case?
No, civil case was post-preliminary examination, pre-jury trial.
Where were the depositions in the civil case in relation to the proffer?
Post-proffer.
Post-proffer.
Yes, proffer is 2021. Okay. I don't know the date offhand of the civil depositions. Okay. I do know that it occurred because we obtained the transcript, as did trial counsel. The prosecution was not a party to that. Now, I say all this because I appreciate advocacy for a defendant as well as that knee-jerk reaction. But it is one thing during the appellate process to argue the interpretation of a court rule and quite another to assign ill intent. And I think that's important for the court to know when reviewing remedy.
Okay, but you're not telling me that it was a boo-boo, right? It was intentional. That there was a willful non-disclosure.
No, Judge.
You guys decided you didn't think you had to turn it over, right?
Thank you for bringing that question up, Judge. And I want to go back to the Nick Ejack statement because I think this is a perfect example of this.
Thank you for the question.
At the last hearing, the co-defendant's hearing, we talked about the recorded statement of Nick Ejack. That occurred in 2021, and when it was decided to have him testify for the prosecution in 2024, we should have gone back through and identified that as a statement under the court rule. That was a mistake and was made without malice. It's not being argued here today because there's nothing exculpatory about it.
Well, I did think it was interesting that I wasn't provided with it. That means no one really cares about it, right?
Correct, because there's nothing exculpatory about it. Now, in the same vein, the proffer letters in 2021 were put in the work category box. They were not revisited in 2024. The law supports, as much as I firmly believe, and that's why we read this, and this is why I'm arguing this with the court, that the law supports my position that the reading of the court rule does not require that. It does not mean that these proffer agreements were shoved in the back corner of an office and decided to conceal evidence from the defendants. It wasn't turned over, Judge. That's a fact. But it would be an error to ascribe ill intent to that.
Well, it was intentional that they weren't provided. I mean, it was...
Right, but I don't want
You guys didn't forget if they existed, for sure.
I don't want to paint the picture, Judge, that we had a roundtable discussion about this to talk about whether or not to disclose the proffer agreements or not, because they were very quickly identified not to be discoverable, Judge. We went through items, we went through statements of witnesses. Do we need to redact this? We went through body-worn camera. What portions do we redact? What portions are relative to the case and fit the court rule? That sort of analysis didn't occur with this evidence, Judge. And I don't want my advocacy here regarding the court rule and the interpretation of the court rule to be mistaken for an admission that we tried to hide anything from the defense. So that's the point I mean, because that's very different. That's an important distinction, Judge. I want the court to know that from the prosecutor's intentions throughout this case, from deciding whom to charge with what crimes, discovery process, trial preparation, and trial itself, were just. And I want to highlight something that is, I believe, a perfect example. This court recalls how we came to have separate trials to begin with. Trying this case twice was a logistical nightmare for a number of reasons, Judge, as this court knows. Our witnesses had to testify twice on international TV. Most importantly, we had to put our victims through this twice, and they had already endured 2 long years of seemingly endless litigation at that point. But it happened because
for everyone.
It was, Judge. And the reason it occurred is because we listened to jail calls, we interviewed witnesses on Jennifer Crumbley's witness list, and we learned of Jennifer Crumbley's desire to present antagonistic defense. We reported that to counsel as well as Your Honor at a status conference, as I'm sure you recall. We did that to ensure the integrity of the proceedings as well as protect the rights of the defendant.
I think that was inevitable anyway.
Either way, Judge, we didn't have to. We learned of it on our own, Judge. Trial counsel did not ask for that. Whether or not the court was going to grant it or not, I can't say. I can just relay to the court what happened to make sure the record is clear. In addition, we created waivers to make sure the defendants knew the dangers of joint representation. We created waivers when the trial counsel split to make sure they knew about how to protect prior client safeguards. We made sure, and we requested that independent counsels were appointed to interview these witnesses in the jail, these defendants in the jail, so they understood the dangers of proceeding. Every time a question was asked of the co-defendant during the trial that might elicit prejudicial information, we asked the jury to be removed from the courtroom, and the defendant herself was brought here to understand that was knowingly happening. Way back in the preliminary examination, when trial counsel was in danger of conflating the evidence as to each defendant, it was the prosecution who stood up and
It's between 4 hours and 8 minutes and 4 hours and 10 minutes is kind of what people are having. So we're close.
made a point to notify the judge and trial counsel. We have separate defendants, separate pieces of evidence. Judge, again, we do this to protect the rights of the accused, and it would be wrong to ascribe ill intent to any real or perceived discovery violation. But let me talk about the court rule. So 6.21b5 says, upon request, the prosecution must provide each defendant with any plea agreement, grant of immunity, or other agreement for testimony in connection with the case. I do not agree with counsel's interpretation of the rule that for testimony does not apply to all 3 phases here, and I certainly do not agree with counsel that these proffer agreements were immunity agreements. I talked about this the last hearing, Judge. If the court has questions regarding that, I can certainly go through it again, but I'm sure the court recalls. I adopt those arguments here today. As much as counsel or the court cannot inject a word or phrase into a court rule, at the same time, we can't make an agreement something that it's not. We met with these witnesses to prepare them for trial multiple times. The proffer agreements never came up again. Their attorneys didn't even show up for those prep meetings most of the time. That is not a situation that we commonly think of as a proffer agreement that must be turned over. So that is an important distinction, Judge. Let's talk about prejudice now. We briefed that extensively. Judge, we also briefed extensively the whole last antecedent series modifier rule. If the court has additional questions on that, I'm happy to answer, but I think counsel, as well as the prosecution, briefed that extensively. Judge, even assuming that these proffer agreements would fall under the court rule, the defendant must show actual prejudice. And that's where we look at the same standard as Brady materiality. And that is why I started off with all of these series of choices that James Crumbley made, irrespective of those 2 witnesses. Evidence is material.
This is Chanel 495-142,
Yes, Judge.
2014 Michigan Supreme Court case.
Yes. And Judge, going back to, I described what happened with the proffer agreements and their non-disclosure. Counsel did make a point to say that I disclosed discovery 34 times and each time chose not to turn that over. That's not true. It was the first time, and it wasn't revisited. That's an important distinction. It's not splitting hairs, and again, it's something for this court to keep in mind when determining remedy. I'm sorry, I interrupted you regarding Chanel.
No, I just wanted to.
Right. I think that's a great case to review because of what happened in that case compared to what happened here, Judge. Sean Hopkins and Nicky Jack were not needed to identify the defendants. They weren't needed to, they didn't have motive to put a case on somebody else. The evidence that convicted James Crumbley occurred wholly distinct from anything that Sean Hopkins or Nicky Jack were involved in.
Well, the prosecution certainly wanted them here, right? Even though it was only a 12-minute meeting, there'd be a small hole in the trial, right, if they weren't here?
Well, Judge, as a matter of trial strategy, we tried to give the jury as much context as we can. It does not mean all the 20 witnesses were essential to the case. Honestly, we could have convicted the defendant with just Detective Rogowski and Lieutenant or Under Sheriff Willis's testimony, Judge, because the bulk of this evidence came through Facebook accounts, text messages, video, as well as the evidence that was sent to James and Jennifer Crumbley. We didn't even need these witnesses for a foundation for that math worksheet. The fact of the matter is, and we made a...
I agree with that.
Thank you, Judge. We made a point about talking about this in the opening, throughout the trial, and closing. Hopkins and Ejak knew this much about the shooter and about the Crumbley household. That's nothing we ran from. Counsel just argued in support of her position that he didn't know about the shooter because he wasn't in trouble. That's true, and we never tried to argue anything to the contrary. He knew this much. James Crumbley knew this, and that's the point. That's the point. It takes a rare set of circumstances to convict a parent of involuntary manslaughter for the intentional acts of their son. That's why it doesn't happen very often. It takes causation, it takes gross negligence, and it takes foreseeability, Judge. And everything else that James Crumbley knew, that's what convicted him. There just weren't very many factual disputes in the trial. That's the crux of prejudice and materiality. I'm with the court.
What do you think about Taylor and Davey, though?
Davey is cited by Dickinson, Judge, in support. It's cited by Dickinson. And the crux of Taylor is that the objecting party should not be put in a better position. This would put James Crumbley in a better position. Dickinson's test of outcome determinative prejudice is the guide for this court, and that is why it is the same test for materiality, Judge. Evidence is material if it creates a reasonable probability of a different outcome. That's the standard. What is material is all of the evidence uncontested that James Crumbley knew about his son, all the evidence that was proved by a number of different witnesses, not named Hopkins and Ejak, proved by forensic download and cell phone towers GPS data, that proved that James Crumbley was grossly negligent, that proved that he was both the proximate and factual cause of death, and that this was foreseeable to him. We did sort of get into the argument on the Fifth Amendment aspect of it, I'm sorry, not Fifth Amendment, regarding the duty. Thank you. If the court would like me to.
I'm going to let her respond to you, and then we'll talk about duty. I issued a ruling already on inconsistent theories and duty and unanimity, right? So.
Not in this case, Your Honor.
Wait, not with regard to this case, but there's plenty of overlap. So I know I'm just stressing that so that you hit the highlights, and I know there's some things in your brief that were not in the brief presented on behalf of Mrs. Crumbley, but yeah. So can she reply to you? Or?
It's whatever the court would like, Judge. And just one other thing that the counsel mentioned that I neglected to bring up earlier, only four people in the world knew about these proffers. That's not true. I mean, Hopkins and Ejak both had their attorneys. We never asked for an NDA. We never told anybody to keep it quiet. I have interviewed gang member witnesses before where their safety would be in danger if things got out, if they didn't testify. That's not the case here, Judge. And I keep bringing this up, the difference of what we commonly refer to as proffer, just because I want the court to contextualize what actually happened. I just want the court to be aware of that. The only aspect on duty I want to bring up is that essential part of duty is foreseeability, which was instructed to the jury. That was part of the jury instruction, so that's all on that part, Judge. Thank you.
Thank you, Your Honor. A couple things. It's always difficult because I can never read my own handwriting. But when Mr. Key stands before Your Honor and says that these proffer agreements were identified as not discoverable, frankly, Your Honor, that's terrifying. It's terrifying to think about potentially how many other cases they haven't disclosed similar agreements. It's terrifying that a prosecution team with 83 years of experience doesn't know that they have to disclose this under Brady. My reaction is not a knee-jerk reaction. It's a reaction that is born out of the Constitution, out of defendant's right to due process and to present a defense and to cross-examine the witnesses against him. So if our Constitution wants to be called a knee-jerk reaction, then that's fine. But my reaction, and I think the reaction of a lot of people, Your Honor, stems from constitutional guarantees that a criminal defendant has. And I'll knee-jerk react to that all day, Your Honor.
She's going for
Your Honor,
blood.
he made a comment and sort of went through this litany of events that speak to the virtue of the prosecutor's office, that because they did the right thing in one instance, it means that there was no bad intent here. Your Honor, I'll tell you what the difference is. The difference is those instances that Mark Keese talked about were instances that were on the record in open court, not in a closed room at the prosecutor's office where they could shove a proffer agreement into a drawer and not revisit it for 2 years before this case moves to trial.
No, I don't think he's talking about instances that were on the record. We had a combined pre-trial conference in the jury room, and that's when the prosecutor raised that there were jail calls from Mrs. Crumbley, basically indicating she's going to flip on her husband. So,
right, but that's known to the defendant. It is known to a defendant. Jennifer Crumbley knows that she's planning on flipping.
Yeah, Mr. Crumbley didn't know that.
All right, I understand that, but she knows, her attorney knows, it's not something that's clandestine. It's not something that the parties aren't aware of.
Mr. Crumbley and his attorney didn't know.
I understand that, but Your Honor, if one defendant knows about it and that defense counsel knows about it, quite frankly, I'm not sure why the prosecutor's patting itself on the back, because defense counsel would have had an obligation to disclose it anyway. So it's not as if they were.
That's a good point.
I'll just leave it at that, Your Honor. Again, I want to stress the distinction between discovery violation and Brady violation. The tests are different. The tests for materiality are different. The discovery violation, Your Honor, is the stronger argument for Mr. Crumbley. I believe he wins under both. But with the discovery violation, that outcome determinative language is not required to impose the sanction. And I 100% agree with Mr. Keys that the case law says, right, that the sanction or the remedy should not be a windfall to the defendant. 100%. The defendant should not be in a better position after the remedy. But to argue that Mr. Crumbley would be in a better position, I mean, that's illogical. That's illogical. If you grant a new trial, you are putting him in the position that he should have been in when his trial started. He should have known about the proffer agreements. His attorney should have been able to cross-examine Hopkins and EJAC about their bias and motive stemming from the proffer agreements. So I really struggle to understand how he would be in a better position. He would have his day in court that he should have had when he first went to trial.
It puts him on an even kill. It does not give him an advantage in any way, shape, or form. It puts him in the place he should have been. And that's a very good argument. I like that, madam. Good job.
I don't know. I guess one of the problems with that in Mr. Crumbley's case is, regardless of whether Mr. EJAC or Mr. Hopkins testified or not, I mean, Mr. Hopkins wasn't going to say, it was me, I was the strong man who purchased that gun and gave it to the shooter.
Sure.
I mean, right?
And I was just going to reply to that, Your Honor. So the prosecution keeps saying that there's this tremendous amount of evidence that's uncontested and uncontradicted. And I really think there has to be a qualified statement to that and context to that statement, because it was uncontested because EC didn't testify. It was uncontested because his medical records couldn't come in at trial. Because if there's one thing my brief makes clear with citations to the CFP report, is that this child told the Center for Forensic Psychiatry that he never told his parents he needed help, specifically his father. That when he was feeling suicidal, he did not tell his parents. He put on a happy mask, a happy face. So when you look to the CFP, there is plenty to contradict the prosecution's theory. It just wasn't allowed in at James's trial.
Okay, well, there's good reason for that, right? It's hard.
I would respectfully disagree.
Well, I guess that would be for the Court of Appeals of the Supreme Court.
Agreed.
I guess I would say to you that we thought long and hard, researched. Everybody involved in the trial spent a lot of time, and there is no allowance at all for those records not to be privileged. Those records are privileged. I don't know what to say. Can I say that some of it is unfair? Maybe. But I think you're supposed to get a tape next week of the hearing we had under seal. But to be honest with you, I think you're going to figure out that when you get that sealed record, it's anticlimactic.
Your Honor, so the sealed record, of course, is from Jennifer's trial, not
right.
There was no separate
right,
sealed
but
record.
It's a reference. It talks about references to mental crisis by the shooter.
Your Honor, I don't.
We're getting in the weeds, right?
Yes, Your Honor.
I guess I understand your concern about not having the records from the Center for Forensic Psychiatry, but both sides, all three sides in this matter, researched, looked at the law. So did I, for many, many hours and many evenings and many times when I should have been sleeping. And there is a feeling of unfairness potentially about that. But there's no question in my mind that those records are privileged, and the privilege is held only by the shooter. So I don't know that there's a way around that.
And I know that this isn't an issue before the court, but certainly there is authority that privileges must bend to a defendant's right to present a defense, his constitutional right to present a defense.
I've seen those cases, yeah.
And because those records didn't come in, Your Honor, the jury is presented with text messages, right? Not even direct testimony from EC that he allegedly told his parents that he was suffering mentally, and you have a complete 180 when he's interviewed at the CFP. A complete 180.
I'm not positive that the prosecutor wouldn't also like those records to come in. That's right.
Oh, Your Honor, the records are relevant. First of all, the records in their entirety are not relevant, right? Because there's a lot in that report that deals with information that James Crumbley knew nothing about. And that's never been contested, right? Certain disturbing actions by EC, right? There's no evidence that James Crumbley ever knew about those activities. So that would be completely irrelevant in a trial against him, and it would be highly prejudicial. But what is incredibly relevant, and what prejudiced his defense, was that the jurors were never told that EC repeatedly told the CFP that he did not tell his parents he was struggling. He did not tell them he was suicidal. And he specifically explained that he didn't do it because he didn't want his parents to think he was not normal, or he didn't want to make them worry. So, Your Honor, that is incredibly exculpatory for Mr. Crumbley. So what I don't like is this suggestion that there is uncontested evidence. It's uncontested because the evidence wasn't allowed in, not because it doesn't exist, Your Honor.
We're talking about the fact that he bought his 15-year-old son, had gone and left it laying around unsecured, and was presented with that picture in advance of coming to the school.
So, Your Honor, and now we're kind of getting into the duty, so can I kind of
Sure. Well, I know you responded to Mr. Keith, but yeah, so you want to talk? I'm going to let you make a record about duty for sure.
Okay.
Okay.
Your Honor, so first of all, I would say that additionally, EC, reported that the gun was hidden from him. He went into his parents' room knowing that they were sleeping and removed that gun at a time when he knew that they would be sleeping and that they had hidden it from him.
They did a bad job.
Not all parenting is perfect, Your Honor. They kept it from him, and they were not legally obligated to lock it at that time. Your Honor, as it relates to the duty issue.
Whoa, what?
So it's undisputed. I don't think the prosecution contests this, that there was no evidence at trial that James Crumbley knew of any prior intention.
It was not illegal at the time for them to have locked. Yes, we do have men in the chat. We have Gerald, but he's doing something, so he can't be very active. Jeffrey, hello. We have David. We have a couple of men. Yes, we do not have a verdict in the Linda Sturmer trial, but for those of you who missed, we do have a Monica Sementilli verdict. She was found guilty on count 1 of redrum, count with lying in wait. Count 2, she was found guilty with the conspiracy to commit redrum. And my glasses are crappy and it's driving me crazy. So, yes, ma'am. Yes, sir. MA had no law keeping firearms away from children. I mean, MI. I understand. I just forgot. But I'm like, do they now? Has that law been passed now? Has anybody done anything concerning that law? I would like to know. I think that should be I think that needs to be a national law, that parents should take precautions, at least lock it up, have the lead away from the lead shooter, those kinds of things. I am a licensed carrier and I don't have children, minors in the home. But when I did everything I could to keep it safe. If something happened outside of that, then I would feel horrible, but I knew I did what I was supposed to do. Okay, y'all, back to the arguments.
Intentional tortious acts by EC. There is no evidence of that. Without this knowledge, Your Honor, he cannot have a duty. There is no legal duty and there is no ambiguity in the case law. In its brief, the prosecution cites from the Muma case, which is a case that I cite, and they cite the following language. Since the law, as stated above, stresses foreseeability as a prerequisite to a finding of actionable negligence in cases of lack of parental supervision, and we find no such foreseeability here, we hereby affirm the lower court's judgment. That's the quote in the prosecution's brief. But if the court looks to just the preceding paragraph, right, you would see that also in the Muma court, it talks about the child in the Muma case, right? He takes his parents' car and he gets into an accident and inflicts injuries. And the court says that the child did drive the car the day before the accident, but this was after his parents had left for the weekend. Therefore, the defendant parents could not have anticipated or foreseen that their son would take the car while they were away, since he had never done so before. Foreseeability, Your Honor, is born out of a parent's prior knowledge of prior tortious intentional acts. That is what makes that child's acts foreseeable and what gives rise to the legal duty. There is no evidence of that in this case. What also strikes me, Your Honor, is that the prosecution asserts in its brief that the cases on which I rely do not include this requirement. And frankly, it's as if they didn't read any of the cases cited in the brief. Your Honor mentioned well, I took it as a comment on the length of the brief, which is fine. I mean, it was long. But it's long because...
It's not that long.
51, that's even longer than the Court of Appeals accepts at this point. But the cases, Your Honor, that are cited, I don't just give the court the name of a case. I explain the facts, the holding, why it applies. And what's amazing is that they make a blanket assertion that none of those cases stand for the proposition that I use them for, and give you no analysis of how those cases are wrong or how they don't say what I say they say by way of copious direct quotes from the case. So if you remember, they criticized defense counsel in their brief, not me, trial counsel, about abandoning an issue, right? Because you can't just make a claim and then completely fail to develop it. That's exactly what they do when it comes to this duty argument, Your Honor. They just want to say to Your Honor, hey, Judge Matthews, what she says the cases say, they don't really say that. Okay, now let's move on. Let's not engage in any meaningful analysis to persuade Your Honor of that point. The case law is the case law. Prior knowledge by a parent is what gives rise to the legal duty. There is no evidence of that here.
Don't you think that the Court of Appeals sort of touched on this?
Yeah, I do think that they did. And frankly, I don't.
They talk about
I'm
this
trying
being
to
an
be
extremely unique set of circumstances.
Your Honor, different.
You don't want to call out the Court of Appeals on the record?
Oh, no, that's fine. I think my reputation there is good enough. But different lawyers will raise issues in different ways. Sometimes lawyering from one lawyer may be more persuasive than the next. I wasn't there. I didn't read the briefs. You know, that's not really necessary for my representation here. But what I can say is, where there is no prior knowledge, there cannot be a duty. And if you look, a case that came out after Crumbley, it's People versus Aish, it's AIYASH, came out maybe even the last 8 to 12 months. It's that horrible case in Detroit where the clerk locked the people in the store and they got into a fight, and then one guy who's locked in there shoots and injures and I think kills one of the other people in the store. Your Honor, you know, one of the reasons why the clerk there wasn't held responsible was because he didn't know this person. He didn't know any prior instances of violence. And that is the same here. That is absolutely the same here. The prosecution has never argued that James knew EC was violent, that EC was ever violent before. And we know from Hopkins, he was not a kid that got into trouble. He didn't get into fights at school. He didn't get into fights in the neighborhood. Nothing. There is no evidence.
Why did he have to know that there was some prior instances of violence?
Because that's what the case law requires.
Didn't he just have to know things about him, like all the things that were happening in his life, including the friend, the fact that there was an unsecured gun at his house.
To suggest that
access to his Instagram
Your Honor,
account.
just first of all, just because someone has access to Instagram doesn't mean they're constantly trolling it. But to answer your question, Your Honor, if you followed Your Honor's,
this kid had silhouettes all over his room, right?
It was a hobby that he did with his mother. That's not. Okay, shooting a gun is not in itself violent. If you're going to the range, I mean, that's essentially saying that anyone who goes to a gun range as a hobby or to practice is violent.
No, of course not. But he knew that his son was and then there was the phone call the day before about him looking up. He was he had to be at school while he was at school looking at bullets and things like that. Like it's not just one thing.
But the law requires. And I'm sorry, I didn't mean to interrupt. But the law requires knowledge of prior intentional tortious acts. Otherwise, there cannot be foreseeability. That's what the case law. I mean, Your Honor, you have cases that I cited where the parents had some knowledge that the children were engaging in sort of somewhat nefarious conduct, but because there hadn't been explicit acts of violence, then the parents don't know about the propensity of that child. You have a child here who engages in a hobby with his parents as a way of spending time together. That is not an act of violence, okay? And to suggest that just because he may have been struggling and feeling sad, which is what Hopkins described him as, right? He just seemed sad. To suggest that somehow gives foreseeability of someone committing a mass shooting, okay? In today's climate, 80% of us are probably sad the majority of the time. That doesn't mean we're gonna go commit a mass shooting, and it certainly doesn't make it foreseeable. The standard is prior knowledge of prior intentional tortious acts. Without that, Your Honor, there is no legal duty for the parent to act. Your Honor, that is my argument as to the duty part. That concludes the duty portion of the program. Does Your Honor want to give Mr. Keys an opportunity? I don't know.
Would you like to respond to the argument?
Just briefly. This has been before this court before, so I'm not going to belabor the point. I believe the court is correct. The Court of Appeals did touch upon this, as well as the court.
Well, I should say that I'm definitely interested in and required to consider each defendant individually.
Of course. Thank you for making that record, Judge, and that's absolutely true. I bring that up only because the issues are so similar, and I believe the court can draw from that. It is, again, a unique set of circumstances, and the Court of Appeals made this point, as did we in the Court of Appeals. And to the jury, a unique set of circumstances where a parent could be held responsible for the acts of a teenage son. Foreseeability is key. I agree. Foreseeability is an essential part of this, Judge, and that was argued to the jury. That's a jury question. Those are the aspects that were put forth to the jury, and the jury made that determination. There are multiple ways. So Elvin states clearly that the law in Michigan is that a parent is under a duty to exercise reasonable care to control his minor children as to prevent them from intentionally harming others, or from so conducting themselves to create an unreasonable risk of bodily harm if that parent knows that he or she has the ability to control his children, and 2, knows of the necessity and opportunity for exercising such control. Of course, should James Crumbley have been made aware that his son was shooting at people in the past or engaging in some other sort of violent, tortious acts, that would be evidence of foreseeability, but it's not required. It's just simply not required. So regarding the duty aspect of counsel's argument, I'm asking the court just to refer back to the first motion to quash that we had. That was what was appealed to the Court of Appeals, in the Court of Appeals opinion. I believe it's clear in that aspect. I do want to go back and make one quick point. When counsel talked about the forensic report, as this court sort of alluded to, and counsel's a bit of a disadvantage because she wasn't here for that argument and it's still sealed, but the court did find...
I think you're going to get it this week.
That's fine, Judge. Yeah. And the point I wanted to make is just so the record is clear that the court did find that there was nothing exculpatory in that. And the court...
was one section, though. I should point out that was one portion of the Forensic Center report that was specifically requested, and we had the closed hearing.
That's correct, Judge. That's correct. And also, Judge, there's no criticism of trial counsel in not pursuing this issue. She removed the shooter from her witness list. Probably.
Okay, guys, I'm going to go ahead and take a quick break. I've been wanting to share this with you. This happened just a little bit ago, and it's
in Boca Raton. Police say the Cessna 310 had just taken off for Tallahassee when the crash happened. 3 people were on board right near the Boca Airport. ABC News transportation correspondent Sam Sweeney is tracking that story for us. Sam, what do we know so far?
Diane, this was a twin-engine Cessna plane, carries typically between 4 and 6 people. We are told that 3 people were on board, but we do not know their conditions. The plane...
We have just hit 4 hours and 35 minutes in the Sturmer trial.
It had taken off earlier this morning from the Boca Raton Airport. It was headed to Tallahassee, but just after takeoff, there was some sort of issue with the plane. They tried to come back, and you can see that flight path there making a lot of circles. That indicates that there was some sort of control issue there. The pilot likely trying to stabilize the aircraft and get it back on the ground, but as we can see from those aerial images, they were unable to make it back to the Boca Raton Airport. That plane exploded into a fireball. And again, 3 people were on board. We do not know their conditions. I-95 in the area shut down. Those railroad tracks going right underneath that overpass of 95 there in Boca. Also, that surface street next to the tracks closed as well as investigators try to figure out what happened here.
So what are the next steps for investigators, or maybe even the first steps this early on?
Well, they're going to...
So just want to give y'all a heads up on that. We will go back to the Crumbley trial. I am watching and keeping an eye on the information on that as well. Thank you, Yana.
We have a whole lot of questions they asked too, and there are a lot of information.
Are we going somewhere else now?
No, I was just responding to counsel's argument regarding the forensic report. Yes.
Okay. Yeah.
Thank you, Judge.
It does.
Your Honor, I'm not going to address the duty issue anymore. I think it's been well covered. The last issue I intended to address was the Fifth Amendment issue. I do just want to just briefly say, a little bit ago, Your Honor mentioned that you had already previously ruled in Jennifer Crumbley's case on some of the legal claims that I think on their face or on the surface kind of overlap. But I do just want to stress to the court that as it relates to the inconsistent theories, there is no overlap between Mr. and Mrs. Crumbley's arguments. They are extremely distinct. They rely on different law. Well, the law is similar.
Well, you told me this in a pretrial, and that is specifically why I did not rule on everything with regard to Mrs. Crumbley, because did persuade me that it wouldn't be fair to not read your brief and listen to your argument. So.
Thank you, Your Honor. So I just wanted to point out, especially when it comes to that issue, the arguments are very much distinct. Your Honor, as it relates to the Fifth Amendment, I don't have a ton to say here. I do just want to point out that the prosecution's argument in its brief really doesn't make sense from a chronological standpoint, because they criticized trial counsel for not filing a motion back in 21 or 22 about EC testifying.
No, I think what happened is that we were all here, and Ms. Smith said, in Mrs. Crumbley's case, this is when they were together, Mr. and Mrs.
Yes, Your Honor.
So she said something to the effect of, I'm going to need the shooter as a witness. And knee jerk, I said, you can't take a fifth in front of the jury, so
of course.
You got to send up a flare if you think that's going to happen, because he can't take a fifth in front of the jury. So I pointed that out, and I encouraged a motion on that issue. And at that time, both of the defendants were together. So Ms. Smith was here and Ms. Lehman was here. So I think that's what the prosecutor is alluding to. That's back when they were together, and I was sort of surprised to hear that, because that would be a whole thing, right?
Surprised to hear what, Your Honor?
That she said that Ms. Smith said she wanted to call the shooter, and then later made it sound like I was required to compel the shooter to testify, right?
I got to take a comfort break. I'll be right back.
Okay, so I
said, bring. This needs to be, if you think that you can bring the shooter in and I can compel the shooter to testify, and this was directed to Ms. Smith, you better file a motion, because that is not how I read the law. And so the prosecutor's point is that Ms. Lehman was there. So anything brought in this case caused a little tidal wave, and everybody to start scurrying around and researching and setting dates for pre-trials and hearings and all that. So everybody in the case knew if there's an issue, you need to tell us what it is.
So, Your Honor, to respond to that, my point is that in 21 or 20, so that hearing happens, I believe it's June 27th of 22. Mr. Keese, if I'm wrong, feel free to. Okay, is that at that point in time there had been no invocation. No one on behalf of EC, and EC himself, had not invoked his Fifth Amendment right against self-incrimination. What had happened at those
Correct.
time periods, thank you.
At that moment.
Correct. So there was nothing ripe to bring before Your Honor in terms of filing a motion to compel testimony, because he hadn't invoked. The very first invocation happens, I think it's 1 day prior to Jennifer Crumbley's case, which is January of 2024. So
I think there was a feeling of shock when she said that, because I think everyone at that time truly believed that calling the shooter as a witness would be tantamount to dropping a bomb in the middle of the courtroom.
Well, Your Honor, okay, I don't disagree, because Your Honor is entirely correct that you can't put a witness on the stand knowing that they're going to invoke. But no one knew whether or not he would invoke. That's number one, because he hadn't invoked. And then once he does invoke, respectfully, Your Honor, that imposes certain obligations on Your Honor. The case law is clear that when an attorney or a defendant makes a blanket invocation of the right against self-incrimination, there must be inquiry, right? The court, respectfully, is not free to simply accept that blanket assertion. So when does that assertion happen? Late January 2024, like a day before. Well, it kind of starts the day before Jennifer's trial. Then it's solidified, I believe, the first day of trial.
Well, the state court defender's office sent a letter and then sent an email.
Right, but the letter respectfully wasn't a valid invocation, because in that letter she concedes that she had not met EC yet.
But the next day she...
Correct, 100%, Your Honor. But once that happens, right, what had to happen under the case law is that EC had to be brought here for a hearing outside of the jury. 100% nothing could have happened in front of the jury. But the court is required to make a finding that the invocation is valid and that he understands it. Your Honor, given the facts in this case, I think it is, I don't want to say highly likely, but a distinct possibility that EC would have testified in his parents' trial.
The prosecution would have loved that.
I don't know that, because then all of his statements to the CFP, Your Honor, about never telling his parents that he was struggling that is the center of their case. These text messages to friend B that he is having hallucinations, which, by the way, the prosecutor's own expert says he never had. Okay, I mean, that goes to the inconsistent theory.
She questioned.
She said, Your Honor, very clearly that people don't share hallucinations. And every time he talked about hallucinating with the doctor, the expert at the CFP, he talked about sharing that his friends saw the same hallucination he was seeing, which led Dr. Anaker to give the opinion that he was not experiencing hallucinations.
Okay, so you're saying I didn't correctly handle the Fifth Amendment issue because I didn't bring the shooter here in his bulletproof vest and put him on the stand and ask him if he was going to take the fifth. But, so you say the Fifth Amendment was not invoked, but I think it was invoked over and over again by his counsel.
No, it was invoked. I don't dispute that it was invoked. I dispute that in 21 or 22 that it was invoked, which should have led counsel to file some type of motion. It wouldn't have been ripe at that point because nothing had been invoked, and I think Your Honor agrees with that. But once he invokes, Your Honor is required under the case law to make a finding if the invocation is valid and to make sure that he understands the invocation. And that didn't happen here. And yes, I do argue that he did not have a valid assertion under the Fifth Amendment because counsel could have asked questions, Your Honor, narrowly tailored his questions, her questions, excuse me.
What question? What question would not be covered by the Miller hearing, the fact that the Miller hearing and the resulting sentence was being appealed? I think everyone in the courtroom at that time was surprised when Mrs. Smith said she was interested in calling the shooter. I can't imagine a way to call the shooter.
Because if the questions asked of EC are confined to information that is already known by the prosecution and by the sentencing judge, how can there be additional incrimination?
I don't know. I can't imagine a question he could have been asked.
Your Honor, I go through a list of 17 of them in the brief.
Did you go on a camping trip? I don't think that he could have answered any of those questions. A lot of those questions are from a Miller hearing because his background.
No. That information is lifted from the CFP report. That's why I specifically tailored it to that.
That's separate, though. That's separate. Just because he answered questions in a forensic center interview doesn't mean he can be compelled to testify under oath.
Your Honor,
questions, but they would also be the subject of a Miller hearing, right?
They were already the subject of a Miller hearing. They were already 100%. Those facts were already known to Judge Rowe. The CFP report was made an exhibit at the Miller hearing, which means the prosecution and Judge Rowe were already made aware of all those 17 facts that I list in the brief that are all helpful to James Crumbley because he is portrayed as some disinterested, negligent father, and the fact is that EC statements at the CFP do not support that. They don't support that.
I know that's your position, but try as I might, I couldn't do anything about that.
I understand that, Your Honor, but it was required that Your Honor make that inquiry. Counsel does not have to ask for it.
I didn't bring the shooter in and ask him. I didn't.
And Your Honor, the only way to remedy that is with an evidentiary hearing.
Okay, so you want me to bring the shooter in and ask him?
I want the court to make sure that it was a valid invocation and that it was appropriate. That's how you correct the mistake.
I guess I would have to say that I'm satisfied that he invoked his Fifth Amendment rights.
That's not the question.
Okay.
The question is whether or not the blanket assertion is appropriate. Respectfully.
I'm feeling confident, respectfully.
Your Honor, that's all I have to say on the Fifth Amendment issue. I did just have one other, and I don't know if Mr. Keese wants to respond. I did have one other sort of point that I wanted to make to the court that kind of culminates everything, but I can certainly wait, or Your Honor can just tell me to sit down.
I'll have you respond. And
thank you, Judge.
One or both of you might not be happy with my ruling, but you won't say I didn't let you say everything you wanted to say.
Thank you, Judge. I'll be brief because I believe the court recalls the June 27th hearing.
For joining.
And I do want to point out that we do assert that Ms. Lehman abandoned the issue, but that's not critique or criticism. That's just appropriate to point out for the appellate posture of the case, Judge. And she abandoned it likely for good reason, as the court has already indicated and read that for instance. Now, the fact of the matter is that the shooter's own expert at the Miller hearing called him a feral child. If that information were all to come out, Judge, like you said, it'd be tantamount to dropping a bomb in the middle of the courtroom. Judge, the fact of the matter is that the information that would come from the shooter, every question would be an issue for him. There's an opinion yesterday from the Michigan Supreme Court regarding juvenile lifers, Judge. This is an ongoing issue. We're in the middle of the appeals right now. He asked for a new trial or to withdraw his plea already. That was denied. That's on the appeal currently, Judge. Anything that would have been asked by either party would be an issue for him in the Miller hearing. I think the court is understanding that. So if the court has any other questions, I'd be happy to answer. But I do just want to refer for the record back to the court's soon-to-be unsealed record regarding the forensic report and its non-exculpatory nature, and the fact that, again, we never stood up and said privilege. We just said, as the court correctly pointed out, he does have a privilege, and all parties research that issue. Thank you.
Well, I did a lot of research about that because, obviously things that he said, the shooter said, would be of interest and relevant to both Mr. and Mrs. in their hearing, in their trial. But there's no support for the release of it. I looked for it because there's just no support for it. It's the privileges belongs to the shooter and no one else. So, what else did you want to say?
I just wanted to kind of close out. I do want to address one statement made by Mr. Keith.
I'm going to let you both say whatever you want.
Thank you, Your Honor. You've been extremely patient this morning. Mr. Keith mentions that that EC's own expert referred to him as a feral child. The prosecution's own expert said that EC was not mentally ill, that he was hopeful at the times preceding the shooting, that he was engaged in hobbies that he found enjoyable. So to the extent that you want to start putting out there what different experts said, it's the prosecution's expert who portrayed EC at his Miller hearing as hopeful and engaged and spending time with his parents and generally had a very good childhood without negligence and abuse. Those are, Your Honor, direct quotes. They are in the brief, and I've attached her testimony from the Miller hearing. So I am not playing fast and loose with the facts, Your Honor. Your Honor, I wanted to just sum up. Every time, Your Honor, that I've seen this topic of the prosecution's misconduct is discussed, whether it was when Jennifer Crumbley's motion for new trial was being arguing, whether it's in the press, the prosecution pivots. It pivots from the attention on its misconduct to the absolutely horrific murders that happened in this case, rather than focusing or even acknowledging their own misconduct. And Your Honor, it is, in my opinion, a very blatant attempt to distract the court and the public from how they failed to give James Crumbley a fair trial, how their misconduct robbed him of meaningful cross-examination and a chance to expose to the jury the biases of Hopkins and EJAC. This case, Your Honor, is gut-wrenching. It is heartbreaking, and it is traumatic for an entire community. But our rules and the court's obligation to ensure due process and a fair trial and full and fair cross-examination cannot bend to emotion, Your Honor. If it does, then our justice system has no integrity, and the rules mean nothing, and the Constitution means nothing. The parties must adhere to the rules, and you must enforce them equally to sympathetic defendants and to defendants who garner the most visceral of reactions, Your Honor. In this room, the law must reign supreme regardless of pain and trauma. And I can just see the headlines now, Your Honor. Callous defense counsel doesn't care about the pain of the families in Oxford. And that is not true. Your Honor, and it's funny, it's ironic because Mr. Keith just mentioned, the movement in juvenile lifer cases. When Miller was decided in 2012 and made retroactive in 2016, our courts repeatedly acknowledged how painful this change in the law was going to be for families, right? Families of victims who for decades had maybe reached a point that they could put this pain and trauma behind them, but we still changed the law. The United States Supreme Court required that mandatory life without parole be reversed, and that all these defendants come for resentencing, despite the pain that they acknowledge it would cause. In civil cases, Your Honor, sanctions are imposed to punish and deter, and all you're dealing with is money. This is a criminal case. This is a man's liberty. It is his freedom. It is his ability to live outside the prison walls. If Your Honor does not grant a new trial, you send a message to Karen McDonald and to her office that you will, and that the courts will, tolerate this type of misconduct, this type of constitutional violation. And perhaps even more troubling, you send a message to prosecutors throughout this state that failing to disclose Brady material Information that is critical to a defendant's meaningful right to cross-examination will not be sanctioned, Your Honor. Mr. Crumbley is entitled to a discovery remedy. The only remedy that can make him whole is a new trial, Your Honor. Thank you.
Thank you. Anything, Mr. Peace?
Just briefly, Judge. Judge, throughout today's argument, I feel that my responses have been measured, and I've said over and over again that it is one thing to argue the law, it is quite another to throw around unfounded allegations. And I sincerely take issue with the fact or the allegation that we prosecute for headlines. We prosecute for victims, Judge, for victims. That's why we're here, and that's why we do this job. James Crumbley was convicted because of the choices that he made, the choices that led directly to the deaths of Hannah, of Madison, of Tate, and in Justin. It was James Crumbley's gross negligence. It was James Crumbley's causation and his foreseeability that was the reason for his conviction, Judge. The evidence in this case was overwhelming. I simply ask that this court review the law, follow the law, Judge. Our brief is detailed. Our argument, I believe, is clear. Thank you.
Thank you. I don't think you can expect something from me in less than a month, probably. I'll do my best, but I've been being very careful, and sometimes I think some of my other 550 cases have taken a back seat to these two cases in the last 3.5 years. So I will do my best to get back to you as soon as possible. All right?
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right.
Okie dokie. We do not have a decision today. We are currently waiting. Let me get it up here. For the Menendez brothers, there's going to be a hearing on them. Trying to get I dropped a window and then it took it a while. So we are sitting here in this position here waiting, along with all the other news media. So as soon as we have anything live, we'll go there. I also have up on queue the entire interview with well, why aren't you working? Do what I ask. Thank you very much. With Kylie, but we also have, which I really want us to watch again before we do Kylie, is in the Lori Daybell trial. We have the brothers interview. He cooks her. And then we have the Lori Daybell from Timeline Breakdown and Closing Arguments of Any Politician. So I'm going to do that first because it's short. It's not very long. And then we'll get into the Lori Daybell stuff. All right. Be right back.
By early 2019, her
I'm getting it, Diane. Hold on.
Damaged by Lori's entanglement with
There's
Chad
captioning.
Daybell, a self-styled prophet who talked about apocalyptic visions and past life connections. Their affair was built on doomsday prophecies and cast a black cloud over the Vallow household. Charles confronted Lori about her infidelity and radical beliefs. He filed for divorce. Fearful for his life, he sought protection, revealing Lori's chilling threats and erratic behavior. Everything came to a head on July 11th, 2019. Charles arrived at Lori's residence in Chandler, Arizona to pick up their son, JJ. An altercation erupted, culminating in Lori's brother, Alex Cox, fatally shooting Charles. Cox claimed self-defense, alleging Charles had attacked him with a baseball bat. In the aftermath, Lori and Chad's bond deepened, their union sealed in marriage just weeks after Chad's wife, Tammy, died under mysterious circumstances. This whirlwind of events unveiled a narrative steeped in betrayal, fanaticism, and a chilling disregard for life, leaving Charles, 2 children, and Chad's wife dead, and Lori inside a courtroom facing yet another murder trial. Tonight we are live with the latest as Lori cross-examines her own brother, Adam Cox. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you with us. Lori Daybell comes from a big family. Growing up, siblings, parents, uncles, aunts, and she seemed to garner a lot of attention in that family. But it's also a family when the children grew up, some of them kind of went their own ways a little bit. However, Lori's brother Alex seemed to have a special bond with his sister and a special role. You see, he attacked her husbands, at least two of them that we know of. Joseph Ryan, he went at him with a stun gun to the groin. He ended up doing time in jail for that. He joked about it in his stand-up comedy routine. But yeah, he went after Joseph Ryan, and then we know he shot and killed Charles Vallow. So this relationship between this brother and sister, very unique. We've heard Lori speak about Alex to other people in not such kind terms, but it seems Alex was dedicated to her and did whatever she needed to get done, including murder. But Alex is dead, so he's not a part of this trial. He's a part of the trial, but he won't be participating in the trial because he's dead. But guess what? There's another brother. His name is Adam. So Lori, there's two brothers connected to this case to a certain extent because Adam was a witness in this case today. Adam Cox. Now, Adam and Lori's relationship, I think, was pretty normal when they were growing up. I think when they got older, they didn't spend as much time together because of Adam's profession. He was in the radio business and traveled around and had jobs in different places.
Sorry, just FYI, we've reached 5 hours in deliberations for the Lori Stermer trial.
Around the country. But he's a part of this case. So if you testify in this trial, if you're called by the prosecution, you are then cross-examined by the defendant, his sister. Sibling cross-examination. That's what happened today inside of the courtroom. It's almost surreal to a certain extent. Think about what this is like for this family. Like, first of all, the family's been thrust into all of this, right? This is why everyone knows things about this family. And it's such a huge story and such a huge scandal and such an incredible tragedy. On top of that, with all the people who have died as a result of what Lori and Chad were doing. So today was the day. Adam Cox called to the stand. He had some testimony. He was in contact with Charles Vallow. And now it's time for the cross-examination. So now Lori gets up to question her brother.
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So, has it been a year, 2 years, 3 years, 5 years,
Something
6 years,
like that.
7 years, 8 years?
Something.
Okay, so you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay, so did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house.
I did see you at that house, yes.
At least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember that.
Okay. So right now it's 2025, is that correct?
Yes.
And so we haven't spoken in about 8 years? Would that be correct?
It's probably 7 or 8 years.
Okay. So would you say up until that point that how often would we communicate before that?
Before what?
Before 2018?
Probably on a regular basis. Once a month, twice a month, 3 times a month.
You know of us living in Hawaii and you were living in Kansas at the time?
Yes.
And in your career, you lived in lots of different places, is that correct?
Yes.
Austin,
Yes.
Dallas,
Yes.
New York,
Yes.
Wichita,
Yes.
Sacramento.
Yes.
Did I miss anything?
Others.
And I was in Texas,
Yes.
Arizona,
Yes.
Hawaii.
Yes.
So would you say that we were not physically close during the past 20 years?
Yes, I would say that.
So, Mr. Cox, did you see or hear or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
Repeat that again.
Okay. Did you see with your eyes or hear with your ears or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
No.
Thank you. No more questions.
He didn't remember the green chili enchilada, chicken enchilada? Shocking. Shocking. Mr. Cox did not remember that. Wow. What was it like inside the courtroom during that moment? Let's bring in Court TV legal correspondent Kelly Craft joining us live from Arizona. I'm trying to think, Kelly, I've been at Court TV a long time. I've seen a lot of trials. I don't think I've ever seen a sibling cross-examination. That might be a first. What was it like inside the courtroom?
Hey, Vinny, it was something to see, I can tell you that. In regard to the green enchiladas, she seemed disappointed that he did not remember them. She was saying, I made them for years for the family, but he did not remember them. It was as if when I was sitting there, it felt like Adam was looking at Lori wanting to be like, come on, I know you're in there somewhere. And it was as if he was just trying to pull something out of her by like looking at her. She did not address him by his first name, which has been a change from what she has done with other witnesses that we have seen throughout this trial, Vinny. She's been going up there saying the first name and the last name. Her own brother she did not refer to as Adam. She referred to him as Mr. Cox. That question on cross-examination, I do think that was a very solid question, a very good question by her, asking if she saw or heard anything about her and their brother conspiring. He said no. She actually had to ask it twice. But then on redirect, there was something from the prosecutor which got him to say more regarding that conspiracy. Why don't we go ahead and play that for our viewers?
When you were talking to your family after this happened, did you actually tell them that you believed that Lori and Alex had conspired to kill Charles?
Yes.
Why was that?
Because Lori had told people that Charles was no longer living, that some guy named Ned was inside of his body, that there was a zombie living inside of him. And Alex didn't respond to any of my text messages when I was supposed to be with him. And he was at that house that morning.
And so he went on to say that he had no doubt that Lori and his brother did conspire to murder Charles. It was interesting because on redirect, Lori began to object, and she said that it was outside the scope, the prosecutor's redirect. The judge allowed the prosecutor to proceed, but after she was done asking those questions, the judge came back, Vinny, and said Lori was technically right, that the redirect was outside the scope. He gave Lori a chance to cross-examine. She chose not to.
Such an interesting dynamic. And to you know, brother and sister and brother.
I have to step out for a quick second. You got this, Diane, for a minute? A short minute? I'll let you clean your glasses. I'm sorry, I'll be right.
And here they are. And it was interesting when she referenced Alex, she said, my brother Alex, not our brother Alex. I thought that was interesting as well. Okay, other than Mr. Cox, any other witnesses today?
Yeah, some really big witnesses after Adam. So a lot of interesting testimony today. Serena Sharp, a friend of Lori's, she took the stand, and it got a little heated when Lori was cross-examining her as well, because Lori was asking her about her testimony, being under God, what she knows, if she heard her actually say the word zombies. Why don't we go ahead and play a little bit of Serena's testimony?
Ms. Sharp, did you take an oath when you came into this courtroom today?
Yes, I did.
Did you raise your hand?
Yes, I did.
Did you swear to tell the truth?
Yes, I did.
The whole truth?
Yes.
Nothing but the truth?
Yes.
So help you who?
God.
So can we agree that this court acknowledges that your testimony here today will be accountable to God?
Your Honor, I don't object to the relevance of this.
Sustained.
Vinny, extensive note-taking today going on between Adam Cox on the stand, Serena Sharp, and then also another big witness. We were actually surprised the state did call Kay Woodcock because it was getting close to the end of the day, but the state did call Kay, this is Charles Vallow's sister, as a witness. Why don't we go ahead and play a little bit of her testimony?
In 2019, again, without going into what Charles said, did you ever believe that Charles was concerned for his safety?
Charles was absolutely concerned for his safety. Lori had sent me a text, I think it was on a Thursday, that she and Charles were fighting because of some stuff she came up with, and that she and JJ and Tylee were at a hotel.
So that was kind of in the beginning of Kay's testimony, talking about how Charles was kind of getting afraid for his life, concerned about his safety. Eventually, she did become emotional on the stand, talking about the death of her brother and several times using the word murder. Vinny.
And you talk about everything that's happened here. Kay and her husband, Larry Woodcock, really the driving force behind peeling back all the layers of what Lori and Chad did. And it all really began with trying to find JJ and reporting him missing. That set everything in motion that is now culminating with this trial in Arizona. Kelly Craft, thank you so much. Let's bring in our think tank. Joining us tonight, private investigator with more than 20 years experience, Jason Jensen. Also with us, retired criminal defense attorney Kirk Nurmi, and former federal prosecutor, president of the West Coast Trial Lawyers, Nima Romani, with us. Okay, Kirk, I want to begin with you and what you think of what we've seen so far in this.
Okay, Diane, I'll take Vinny, which is at the top right with the plaid background, and the man in red or orange, if you'll take the other two. All right. We have to plan it, y'all.
Cross-examination by Lori Daybell inside the infamous Maricopa County Courthouse where you spent many, many years.
Yeah, you know, she's really not doing herself any favors. I think she keeps shooting herself in the foot at every opportunity. You know, she's got this question that she considers a got you question. Did you, you know, see me or hear me conspire to kill my husband with my brother? And but that is opening the door to response. And we saw Adam Cox sternly, you know, sit there after the state got on redirect and say, yeah, I immediately knew it was them because they were talking about these dark spirits, what have you. Then she did the same thing, didn't learn her lesson the first time, did the same thing with Kay Woodcock, who went in and said, hey, no, I didn't hear anything directly, but I saw lots of evidence, which of course is an objectionable comment, but Lori, not being a lawyer, doesn't know that. So all she's doing through this cross-examination, she thinks she's making all these great points, pointing out God, everything else. She's doing herself no favors. She's making the state, making a job easier for the state.
Nima, do you think, though, she scored some points in undermining Adam Cox's credibility when he did not recall the green chili chicken enchiladas?
Vinny, I don't think I'll ever forget that line of questioning. Maybe because my expectations were so low. Let's not forget, Lori Vallow was found to be incompetent. If you recall her statements at her sentencing of the death of her 2 children, I thought she would be off the rails. I thought this would be worse than Darrell Brooks, but maybe because she was somewhat coherent, I didn't think it was absolutely terrible. Did she score any points? Probably not. She missed the whole issue, right? You have Adam Cox talking about Spirit Ned. You have Serena Sharp talking about the zombies, right? And they're talking about evidence that puts her, really implicates her in this murder, even though she didn't pull the trigger, her brother did. And she's talking about really bias, right? That her brother hasn't seen her in quite some time, and Adam's memory is poor. She didn't really get to the heart of the matter. And like Kirk said, she really opened the door to a lot of speculation that no lawyer would have allowed in. So really poor job, but maybe because I expected an F-, this was just an F today.
All right, Jason Jensen, in trying to figure out exactly what was going on here, what the dynamics are, when you have someone like Adam Cox who can take the witness stand, who grew up with Lori, grew up with Alex, knows them and knows how different things became with them, right? Like, it's like something happened. Yes, they were physically, geographically distanced because Adam is traveling around the country from market to market, working in his profession. But at the same time, it's clear to me that he believes that, yeah, there was a conspiracy. And yes, my brother and my sister, not proud of it. To me, that is such important insight for this jury.
Right, Vinny. The thing that was very clear to me is the fact that Lori's grilling Adam about how estranged they had become doesn't serve her well, because what she really needed to focus on was how this is aberrant behavior. This is, you know, something that
Thank you, Jamie.
within her character or Alex, and that is there a possibility that this was self-defense? Because bear in mind, there was an injury and there was conversation of Alex had with Chandler police before all this went down.
Kirk, how different would this be if Alex Cox did not pass away on the toilet?
You know, that's hard to say, because we have this conspiracy to commit murder charge, but the focus of her defense, Lori's defense, should be that there was no murder, that it was an act of self-defense. So if Mr. Cox were still alive, and
wait, Kirk, when you say Mr. Cox, you have to, which one? Because Lori was referring to Adam as Mr. Cox, just so there's no confusion.
That's right. Okay, when we instruct Alan Cox, the deceased, if he were tried first, if they used this evidence and he were tried first, that would make this a completely different ball game now, because he would have been convicted of a murder. That evidence would have come forward, and then that issue wouldn't even be apparent. But the thing is, for the state, is that Miss Vallow doesn't seem, Miss Daybell, sorry, doesn't seem to be convinced or understand that that's the issue. This is a conspiracy to commit murder. It's not an enchilada case. It really relates to the murder. And she's not fixating on the fact that there wasn't a murder. Chandler Police made that conclusion years ago.
The whole enchilada. All right, Jason Jensen, Kirk Durbin, Nima Rahmani staying with us. When we come back, we're going to have more from the Maricopa County Courthouse, taking a look at some of the other testimony from today and some of the issues crucial to this case, plus coming up next hour. Tonight on Vinnie Politan investigates the retrial of the century. Jury selection is justified. He says Nick Schneider. It's actually, I believe, Ned Schneider. But all this very bizarre behavior. But I think he also knew it was dangerous to a certain extent. He was trying and reaching out, trying to get help, but no one was apparently able to help him and to save him from Lori. Today in the courtroom, Christina Atwood testified, defendant's former friend, so this is Lori's former friend, talking about these same issues about Lori, talking about Charles.
Did that help refresh your recollection as to whether or not Lori had ever told you that her husband, Charles, was possessed?
Yes.
And did it help refresh your recollection as to whether or not Lori Vallow had told you that her husband was possessed by some spirit that had a name?
Yes.
And at that time, you could not recall what the name was?
Correct.
Did you hear Lori speak about Charles being possessed more than once?
Yes.
On more than one occasion?
Yes.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Did you ever participate in any castings?
Oh.
Let me ask it this way. Did Lori ever talk to you about casting?
Yes.
What did you understand that to mean?
It was praying for dark spirits to be cast out of someone.
Were you ever involved in a casting for her husband?
I was in her presence when she prayed for that.
So it was a real thing, and she was not keeping this private. She was publicly talking to other people about these dark spirits. Let's bring back in our think tank, still here. Jason Jensen, Kirk Nurmi, Nima Rahmani. Jason, to me, this has always been one of those issues. And I think it's a big issue about what is really going on between the ears of Lori Daybell. Does she genuinely believe that Charles has been invaded by zombies, that he is Ned Schneider, or is it some sort of a pretext that she's using to persuade Alex to kill him and perhaps to explain the death, the premature death of Charles and others when they die before they're supposed to die?
Right, and that goes to the heart of this case, the heart of the trial. While the prosecutor is trying to say that this is, a basis for the conspiracy, one can argue that, it had the dehumanizing effect, and Alex was more inclined to use
Trying to get this dang captioning to stay.
of
It keeps
violence
dropping.
against Charles because of this conditioning, but it doesn't necessarily mean there's a conspiracy per se.
Let me ask you, Nima, what are your thoughts on that issue? If the jury believes that Lori actually believed that he was a zombie, like legitimately believed he was a zombie, that the spirits, dark spirits, had taken him over, do they cut her any sort of a break here?
Potentially, yes, Vinny. Let's go through it. So the conspiracy, that's a specific intent crime, which means that you have to have the intent to enter into an agreement to do something unlawful, an agreement to kill. So there's that element.
Okay, Ronnie. If I was in that group and there, once the casting begin, I'd grab my nasty green enchiladas and run out of the house. Oh, y'all. Oh, wait. No, we're good. I thought we were on the verdict watch. We still don't have a verdict. 5 hours, 22 minutes. We still don't have verdict. Okay, I don't know why these captioning is not staying where I put them. My apologies. Okay, Miss Diane, let's get going again.
Potentially negate the criminal intent or the mens rea there. Or with respect to self-defense, if it's an unreasonable belief, we've talked about perfect versus imperfect self-defense, it can reduce murder to manslaughter. If you genuinely, in your heart of hearts, but unreasonably believe that you're at imminent risk of death or serious bodily injury, you kill someone, it's not murder, it's manslaughter, not conspiracy to commit murder. Now, of course, we know that Lori Vallow here, or Lori Daybell, is free-rolling, right? She's serving a life sentence in Idaho. Her attorneys did a masterful job of saving her life and getting the death penalty off the table. So she has nothing to lose here. She might as well trial this case, try it pro se, throw all these arguments out. I don't know if she understands these legal issues and can coherently make these arguments to a jury, but potentially, yes, if she did have that legal knowledge and sophistication, she could do so. Don't think it's going to work, though.
All right, Kirk, I want to play for you a little more testimony from Christina Atwood talking about something that Alex said. I'm going to play it, and then I'm going to see if you pick up on the same thing that I'm picking up on here.
Can you tell us your impression of Alex Cox? What was the impression you got from meeting him and being with him for a night?
I was put off by it.
Why?
He was pretty loud and outspoken, I guess. And I was very uncomfortable with what he was talking about. He stated he wished that he could just kill Charles.
Okay. Was Lori around when he's saying this?
Yes, one of the times.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
Okay, Kirk, here's what I'm hearing that is very significant there. Is that Alex said he wanted to kill Charles, not Ned. Not Ned, who's the supposed spirit, zombie, whatever, that takes over Charles's body, but he wants to kill Charles. I think that's huge, but maybe I'm overplaying this because I'm obsessed with Ned Schneider.
Yeah, well, you know, I would look at it a slightly different way, Vinny. I think it's evidence of premeditation. He's talking about wanting to kill Charles, right? There's not so much talk of the casting. There's not concern about the spirit. There's just a desire to kill. And then we think about the timing of this killing, Vinny. What's the most crucial time for someone who's a victim of domestic violence? That time they're going to leave. So he's talking about killing Charles. Charles is talking about packing up, getting away from Lori. He's starting to date. He's got this plan with Adam Cox to revoke Lori's temple recommend. All that speaks to premeditation and conspiracy. So to me, that's where that fits in the puzzle, whether we're talking about Ned or Charles. It's premeditation of Charles, the death of Charles.
All right, Jason, I want to take a listen to one other piece of testimony from Christina Atwood. Big witness, I think, for prosecutors, talking about something that Lori did.
During this same gathering on June 9th of 2019, did you hear Lori Vallow say anything about Charles that was also disturbing to you?
Yes.
What did you hear her say?
I heard her say that she had crushed up some of JJ's medicine and put it in his drink mix.
Did it sound like a significant amount of medication?
Yes.
When you heard this, what were you thinking?
I was disturbed.
Jason Jensen sounds like she attempted a Corey Richins.
Yes, that's what it would sound like. And I think it would be something I would object to, because that doesn't necessarily mean that it happened. Many times when there's divorcing couples, and they're having conversations with family members or friends, they say things in jest. It doesn't necessarily mean that it's evidential.
Okay, think tank staying with us. When we come back, let's change the mood here a little bit. Let's talk about Chad and Lori's love story. There it began in 1990.
And pulling those messages.
What did you hear?
Casting.
Sorry. Trying to find it. Where did the break go?
Those
Okay, we'll start here.
messages, did they appear to reference and correspond with the James and Elena, the characters?
They did.
Was there indication in there that the events in James and Elena were occurring in real life?
It appeared to, yes.
Again, as you were compiling and pulling the messages related to James and Elena, did you, in your opinion, did it mirror events occurring in real life with Chad and Lori?
Yes.
I have no further questions.
Chad Daybell's an author, very prolific, wrote and self-published a whole bunch of these books that, Lori read and became infatuated with them. But Chad also wrote a novella about these two characters, James and Elena, whose lives seem to mirror Chad and Lori. So let's take a look at the Chad and Lori timeline first. We begin in 1990. Chad and Tammy Daybell get married. Everything seems set up. A nice, clean, great life. Lots of kids living in God's country, right? 2006, Lori and Charles Vallow marry. Finally, Lori, on husband number 4, finds the man that, is just a rock, is solid. 2015, Chad and Tammy Daybell moved from Springville, Utah to Salem, Idaho. The fall of 2018, Lori Vallow meets Chad Daybell at a religious conference in St. George, Utah, and there it begins. July 11th, 2019, Lori's brother Alex Cox shoots and kills Charles Vallow in Arizona. August of 2019, Lori, Tylee, JJ, and Alex moved to where? Rexburg, Idaho, close to Chad. September 8th, 2019, Tylee Ryan is last seen alive. September 8th, 2019, Chad Daybell signs an application to increase his wife Tammy's life insurance policy. September 22nd, 2019,
Read
JJ
yourself.
Vallow
He's
is
moving
last
too
seen
fast for me.
alive. October 19th, 2019, Tammy Daybell found dead in her home in Salem, Idaho.
And I'm not hearing very
then,
clearly.
Just a few days later, November 5th, 2019, Chad and Lori married in Hawaii. Now, let's go back a little bit. Just a few days after Charles Vallow is shot and killed in July of 2019, but several months before Tammy tragically passes away, gets murdered, Chad texts to Lori a romance novel. And again, it's about James and Elena, who seem to be based upon Chad and Lori. Take a listen to that text as read by Cody Thomas.
But on the morning of October 26th, James arrived in St. George, still a bit baffled by the message he had received. MG introduced James to her friend Elena. When their hands touched, he felt a shock pass through him and his heart started beating fast. He had glimpses of them walking dusty paths together, and he realized they had been married during the life of Jesus Christ, and they had been very close to him. At this time, their spirits could not be restrained any longer, and a long-awaited makeout session took place in that lobby. This was manifest in the mortal world to James and Elena through the scientific phenomenon known as loin fire. As they talked, James had a burning desire to make love to her, but he wasn't sure she felt the same way. The erotic tension continued throughout the afternoon. James could only think of her. His desire for her was indescribable. Thankfully, she had worn 16 layers of clothing to survive the 80-degree weather, so he was not fully aware that she truly had the body of a goddess. Her dimensions were exactly what he had always fantasized about, but that revelation would have to wait a month. They would both attend the same event in mid-November, and it seemed like that day would never arrive. He knew they had been married before, and they had been close friends with the Savior when he lived in Jerusalem. That relationship was now meant to continue in this lifetime. They hungered for each other, and he leaned forward and fulfilled a promise he had made to her a few days earlier. He gently kissed her tender lips, and the same heavenly electricity filled his entire body. The passionate magic they had felt many centuries earlier came surging back powerfully. James moved to the couch, and Elena straddled him effortlessly, as if they had done this thousands of times before. She
I ain't signing this.
on him.
I am not signing this smut. I'm not signing it. If I'm getting paid, I'll sign it. But I ain't signing this on national TV. No, thank you. Y'all can just listen. They can read the words. I'm not trying to be
And they
tacky,
pressed
but
their loins tightly against each other. They were still fully clothed, but the intensity of the
holy
intimacy
crap.
was undeniable.
Oh my. Oh my. Nima Romani, Chad Daybell, are you surprised that he's not a defendant in this case?
I'm not surprised, Vinny. The prosecution is doing its job by bringing the Lori and Chad romance story into this case to really dirty Lori up and explain why she would kill her husband, Charles, with the help of her brother. But like you said, I mean, that timeline's so important, right? Charles is killed. Then Tammy Daybell is killed a short time thereafter. The kids disappear. Chad and Lori are in Hawaii. We're covering this on court TV almost every day when the kids are missing. I mean, this was big, big news. And this was the doomsday cult couple. They thought the world was going to end, the apocalypse in 2020. The pandemic happens. Vinny, you're covering it from home. We're covering this case from home. I remember it vividly. The story absolutely is relevant to the Charles murder. But you can't try that case within this case. So the prosecution is doing enough. It kind of reminds me of actually Bob Durst when the trial was really about Susan Berman, but they bring in evidence of these other murders, 2 other murders, to dirty up that defendant and explain why Durst would kill his best friend. Same thing here. This is a good explainer motive for why Lori would kill her husband. But you don't want to bring in all that evidence in this case when you really have a slam dunk or, as you like to say, Vinny, a layup with a pro se defendant who's not represented.
It's a layup. Slam dunks are not easy. Try doing one. No one on this panel tonight, I don't think, could do a slam dunk. Maybe Kirk back in the day, because he's huge. What are you, like 6'10"? But I certainly could never do a slam dunk. So, Kirk, do you want to talk about the loin fire, or what do you want to talk about?
I want to make sure Cody's okay after having to read all that stuff, because that was pretty darn tough read. I don't know how he got through it. But listen, Vinny, I think Nima's right as it relates to the point of not being able to bring Chad into this case. But it does illustrate Chad. You know, we know he was a grave digger. He was this guy who probably didn't feel like he had a lot of respect in the world. So he elevates himself with these false prophecies, these romance novels, everything else, and was able to ensnare someone like Lori into the plan. Whether that was because she wanted to, you know, be rid of her husband and have $1 million, or whether because she really believed in it, we're never going to know. But we know that her actions to be with Chad and to kind of live this fantasy life, this insane life, right, were done in order to, you know, her murder of Charles was done in order to facilitate this. So I think it's very clean of the prosecutors to focus simply on Lori.
And Jason, Jensen, when we talk about everything that has happened here, right? This is the 3rd trial that we've gone through. It seems every spring there's another Daybell trial. Looking at this, what happened here to me was fueled by this love affair / sex affair. They are lusting for one another. That is clear to me. But then there's also this whole thing about us leading the 144,000, and yeah, we want the $1 million life insurance policy.
Right, it seems all too convenient, doesn't it? Frankly, I'm surprised that they went through the trouble of doing this trial. She's already faced a double life sentence in Idaho, and the key perpetrator of Charles' death, Alex, is already gone. So this is really a tougher trial to get a conviction with, but obviously Arizona thought it was worth their time.
Jason Jensen, Kirk Nurmi, Nima Romani, great to have you here. The Men's Club, here we go. We'll see you again really, really soon. When we come back, folks, I am going to reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, we are just days away from openings in the retrial of the century, Massachusetts.
Okay, y'all. We're going to take a quick sign break on that one. Diane. That's why you quit interpreting, huh? You wanted me to pick it up and be the bad guy. Unmute yourself. I can't.
Honey, I'll interpret anything, and I have interpreted just about anything if they pay me. But to just interpret smut for interpreting smut's sake, nope.
Nope.
I don't do it.
Neither. Nope, me neither. I mean, if we're getting paid and we're on the clock.
Yeah.
And it's a deaf person to deaf person live,
Sure.
we're required under law
to interpret it. I have sworn more being an interpreter than I ever swore in my life.
Uh-huh.
And it never fit. It doesn't fit. It just doesn't fit my mouth well, you know? But I tell you,
I just pretend I'm a sailor.
I tell you what, I remember I was doing some interpreting, and the person who sent me said, "Let me tell you, this person is certifiable." I was like, okay. I had no clue until I got there, and this person was certifiable. They were MFing every 2 words out of their mouth, and they were MFing to the 2 policemen standing there. And they looked at me and said, "Ma'am, you can't talk like that to us." And I went, "Not me, her."
I'm not the one talking. It's my voice. It's her words.
Her words. Yeah. And so it was an interesting situation because not my language. Sorry.
That's why I won't do video relay phone calls like Sorensen or anything like that.
What you're going to get.
Because so much of it turns into Xing phone calls.
Oh, absolutely.
And what sucks is you've got to copy each moan, groan, and word on both sides, the speaking and the deaf.
No, thank
you. It sucks.
That's not my cup of tea.
Well, I would tell them I am not capable of that. I am not a... Monica Sementilli learned sign language and you can interpret smut calls. Monica Sementilli learned sign language and you become an operator for the deaf.
If you want to be a porn star, all you gotta do is do your...
If you want to be a home star, learn ASL and you can do it both in the deaf and the hearing way. Oh my God. Well, she got guilty on all counts.
So you said. Well, she's in life.
All counts.
She's for life, right?
We don't know yet, but that's the thing. Let me give y'all a real quick update on where we are because we have a lot of things going on today. I want to thank everybody so much for watching. We have hit 202 people currently viewing us at this time between X and YouTube. Thank you so very much.
This one. Yeah.
So right now, this is a Menendez brothers outside the courtroom. The court is happening at this time.
I don't know where my combs are. I'm like, I got a hand over here and a hand over here trying to figure out where to put my combs to kind of calm
Okay.
hair down.
So hold on a sec. So we have the Menendez brothers, and they are in a hearing right now. The latest Menendez court appearance where I wish that trailer moved a little faster. LA District County attorneys Nathan Hockman is expected to withdraw the resentencing motion. We will hear from them as soon as they go live. Right now, that's where we are. Everybody's waiting all afternoon outside the courtroom. We also have the Tylee Ryan talks to police after Charles Vallow was unalived and killed. And then I gotta listen to this testimony again of the brother. So, how long do I have you for, Miss Diane? Oh, I gotta unmute you. Sorry.
My time is 3:24. You probably got me till about 5:36.
Okay.
What are the Mendez's brothers? What did they do? I forgot.
They were the ones that unalived their parents
That's
back
what
in the 90s, and now they're claiming that it was kind of a sort of self-defense.
Their parents were asleep, weren't they?
Yeah, but they said they did it because the father was actually abusing the brother.
My hair's crazy. It's gonna fall off my head.
Well, guess what? You can just pick it up and put it back on,
I
huh?
will, yes.
Linda Sturmer's jury has been deliberating for 5 hours and 30 minutes. Now 5 hours and 43 minutes.
And she is the one who her husband was burned, right?
Was burnt and then run over by a van.
Yeah.
And died of the effects of the burning and the blunt force trauma.
And laying on top of him.
Ran over him. Okay. So we're gonna hop over. I'm gonna have you interpret this, if you don't mind.
Sure.
I kind of liking this feed. We'll see how it works with this. I think with her, we're gonna have to actually do this.
Well, up in
if
the
you guys
works well because then you can see the closed caption across the bottom.
Well, it depends on the format. When we had those 4 people,
yeah,
we're cutting off 2. So it depends on the format.
Yeah.
But I'm going to bring this on trial. I can't have us this way or this way because it blocks her. This is the daughter of Lori Vallow, who is no longer alive.
Okay. She killed her, right?
She unalived her.
She
Yes.
unalived her. How sad.
I will be we're gonna have to team up. You're gonna have to do the girl. I may not be able to hear her.
Okay.
And I will do the investigator.
All right.
Let's see who I can hear.
Yeah.
For someone whose dad just died, how calm she is.
What? Look how calm she is. Oh, that is so sad. She's how old?
Yeah, you can tell she's upset, but no cry.
How old is she?
About 15, 16. Hello, Adele.
She put Lori under the tree.
Hello, Adair. But I like to be in the drawing. We're now 5 hours and 46 minutes into the Sturmer verdict.
How's Gerald?
Spell your name because we're all taking guesses on how to spell it. We're
No
not sure.
captioning.
Tylee.
Okay, I'm sorry.
Aylee.
And what's your last name?
Ryan, Ryan.
And your birthday. And then
Hey,
do you have
bleep
a
it
phone?
out.
Yeah.
What's your phone number?
Bleep it out.
Okay. So I know this is going to kind of sound like kind of a silly question because it's super broad.
but can you basically tell me what happened today? And you can start at whatever place makes sense for you to kind of start and explain. I'll probably kind of ask you questions as we go a little bit.
So I woke up probably around like 7:50, I want to say, because I heard yelling from like right outside my door. And I don't even know what I heard, but I immediately like jumped up, and I have a baseball bat because when I was living at my uncle's by myself, I just wanted something to like feel safer, and I'm not old enough to get like pepper spray or anything, so I was like, okay, I'll get a baseball bat. So I have that.
So your bedroom, you said right outside your bedroom door, and I didn't go in the house, so I'm at a little bit of a disadvantage. So what is your bedroom door open to?
My bedroom door open, so the room that my uncle was staying in, the room that's kind of like the guest room, if my room's right here, that's right there.
Okay.
And then my little brother's room, and then kitchen's kind of back here, so it's like a little hallway, and then right here is kind of where everything happened.
Okay.
Like the big, you walk in and...
Like big great room, kind of living room?
Yeah, right now it just has mirrors up because my mom wanted a dance room,
Okay.
so yeah.
Okay.
Kind of unconventional, but...
Hey, whatever makes you happy, it's your guys' house, so...
Right, so yeah, I immediately just jumped up and I grabbed my baseball bat and I opened the door, and it was my stepdad, you know, outside the doorway, and then my uncle kind of in the doorway, and then I could hear my mom behind him, and he was just screaming at both of them, like, I don't even know what he was saying, because honestly I was just too, like wired, I guess. So I told him to take a few steps back. I was like, you're too close, you need to step back, and he was like, don't tell me what to do, and I just kind of just stood there, and then my uncle kind of moved out of the way, and then my mom kind of went past him and into like the big room.
Okay.
Where everything happened, and so I walked with them, and then I...
So they were more in the hallway?
Yeah, they were at, like, the end of the hallway, basically. And so my mom walked all the way around, and he kind of followed them, and I just kind of stood. My uncle was, like, right here, and then my stepdad right here, and then me and my mom were kind of right here. And I didn't do anything with the baseball bat. I kind of just held it there, and he was getting really close to my mom, so I kind of stuck it out, like, between them, and they were both just yelling, and he was like, if you hit me with that baseball bat, you're going to go to jail, and I just kind of stood there with the baseball bat, and I didn't really say anything.
When you said they were yelling, who was yelling?
It was mostly my stepdad.
Okay.
Well, he was really the only one, like, yelling. My mom was kind of, like, responding, but I honestly couldn't tell you what they were saying. It was kind of just, like, all jumbled up in my head. And so I just kind of stuck the baseball bat out there, and then he just grabbed it and tried to take it. So I held on to the end, and then eventually I fell, and he kind of took it into his hands like he was going to do something with it, and that's when...
So when you fell, he ended up with the bat?
Yeah.
Okay.
And so I fell to the ground, and then my uncle kind of, like, I saw him take a step back, so my uncle, I think, grabbed him and kind of took him back so he couldn't, like, do anything.
You saw your stepdad, like, take a step back?
Take a step back, because he was really close to begin with, and then and so my mom said to go with JJ, and so I ran out the door, and then I kind of just stood there with my little brother. He was in the front seat of the car, and so I just kind of opened the door and just stood there, and, like, he was trying to get out, and I was like, no, we have to stay. We have to stay in. And I was like, oh, like, I told him, like, do you want to go in the Jeep? And then he was like, no, and then I realized that my car was blocked in, so I couldn't anyways. I was like, okay, like, just stay here, and then eventually my mom came out, and then we left from there.
Okay.
Yeah.
Do you know what happened inside of the house? Has your mom kind of explained it all to you?
I just kind of asked her, like, because I heard a noise, which I know what it was now, but it sounded like, because I knew that the baseball bat was in there, it sounded like someone, like, took it and hit it really hard against the floor.
Okay.
And so I was kind of like Al's okay, right, because that's my uncle, so I just wanted to make sure that, like, my stepdad didn't do anything to my uncle and stuff, and so she was like, no, like, I was fine, like, we're just gonna take JJ to school, and I was like, okay, so I just got in the car, and then we went to Burger King because my little brother wanted breakfast, which was chicken fries for no reason.
Okay, I do dinner for breakfast all the time.
Breakfast for dinner and dinner for breakfast.
So, to kind of back up a little bit, so you had talked about your stepdad, when you put the bat out, your stepdad was coming towards your mom. Can you describe to me a little bit better kind of what was going on there? Like, is there a reason you put the bat up?
Yeah, he was walking towards my mom, and I just didn't want him to do anything, so I kind of just stuck out the bat. Like, my mom was right beside me, and he was right there, so it wasn't, like, between them.
Okay.
It was kind of just, like, I just stuck it out to be, like, keep your distance, kind of.
When you say you didn't want him to do anything, what did you think he was going to do?
Hit her.
Okay.
Yeah, it's, for the most part, been pretty, like, mundane, but there have been a few, like, violent times with him when I was really scared that he was going to hit me or hit my mom, like, just because everything was kind of crazy. Me and him have always kind of not gotten along, like, just since I was little. And so there have been a few times that we've gotten in fights and stuff like that, and so, so I'm just kind of always scared of that.
Yeah.
Yeah.
And then, so that happened, and he grabbed the bat from you. So kind of tell me that again real quick.
So I kind of stuck it out, and this is when he was like, if you hit me with that baseball bat, you're going to jail, and I didn't say anything, because I'm like, okay. And so I'm holding it by, like, the end of the bat, like, the place where you hold it, and so he kind of took it, and I kind of, like, lunged forward and kind of lost, like, my footing. And so my mom was like, just let go, and so, I kind of, like, slipped and I fell, kind of on, like, my side.
Okay.
Yeah, and then from that, my mom said to go to the car, so I just got up and ran out the door.
Okay, did you see, when you fell towards your side, did you see what he did with the bat?
No, I wasn't really looking in that direction, because from where I fell, the door was kind of more in my line of vision, because I fell looking this way and the door was, like, right there, so I didn't look back.
So he was at a different line of sight than what you were looking at?
Yeah.
Okay. And then at some point you saw him kind of take a step back, and from what you're saying, and tell me if I'm wrong or not, you didn't necessarily see your uncle pulling back, but it seems like that maybe...
It seems like he wouldn't have taken a step back on his own, so it's more of an assumption. I'm having a brain cramp. Stepfather?
Say that again.
Stepfather?
Stepfather and uncle.
Stepfather. No, but signing.
Stepfather. Yeah.
Okay, I was right. Okay. Than anything, I didn't see him physically take him back.
And does that make sense based on where your uncle was at that time?
Yeah, he was behind him, because he wasn't on this side with me and my mom, so he was behind him.
Okay.
Because that's kind of just the order where everyone walked out.
And when that happened, and then your mom told you to go, did you see what happened with your stepdad and uncle?
No.
Okay. And then once you went outside with your brother, you never came back inside?
Oh, I went to go get my mom's purse from inside so that we could have, like, her wallet and everything, but this was all happening, like I said, like, in the bigger room right here, and so I went through the garage door, and so the garage door is right here, and then there's, like, a little hallway, and then this is kind of where everything is, and then this is my mom's room. So when I went in, I kind of, like, just tuned everything out, ran to my mom's closet, ran back, so I didn't see anything, I didn't hear anything.
When did you go back in and get her purse?
After my mom came out.
Okay. So after you heard that loud noise?
Yeah.
Okay. And when you heard the loud noise, was your mom outside or inside?
I'm trying to think. I think she was inside when it happened, and the door opened, like, immediately after.
So very quickly after the door opened?
Yeah.
Okay.
So it wasn't like a long period of time, because I remember not like thinking about it for that long, and if my mom hadn't come out immediately, I would have, been thinking about it for a lot longer than I had.
So obviously I don't know like your mom and stepdad and uncle like you do. I don't. So can you tell me kind of where the three of them were at kind of emotionally and how they were behaving when all this was happening?
When all this was happening, or like before?
When all this was happening. So like when you came out of your room and he took the bat from you and...
Yeah, so my stepdad was like, he was like, I don't even know how to explain it. He honestly just looked like kind of a crazy person.
Okay.
Like screaming, and like his face was beet red. He just looked like really mad. I remember when he took the bat from me, I saw his face for like a split second, and I honestly like, it didn't even look like him. He just looked like pure like rage, like he was just seeing red. So I haven't really seen him like all the way like that before. That's like the craziest I've ever seen him. And then my uncle was kind of calm, like not super calm. Obviously it was like a stressful situation, but he's like, I don't know, he was kind of just standing there in the doorway, kind of just being protective of my mom, but he wasn't yelling or really saying anything.
Okay.
And my mom was just kind of, he was yelling and my mom was kind of just like talking.
Okay.
So, yeah.
But you don't remember, if you do, like what your mom was saying at all, or what he was mad about?
No, not really. I'm sorry.
Okay. It's okay.
Honestly, like
we're talking about something that probably happened over 2 seconds of time. So.
Yeah, honestly, it feels like 2 seconds and 40 minutes at the same time.
Yeah.
So I don't remember what they were really saying. I just kind of heard yelling over everything. I don't know. I kind of just do that whenever things are like really loud. I kind of just like tune what people are saying out, because I don't know, just yelling isn't fun, obviously, for a kid to hear. And with my biological dad, I always heard him like screaming and stuff, so I kind of just learned how to like tune it out.
So when you woke up to yelling, and you had said you weren't sure what they were actually saying, did you know who was yelling when you heard the yelling? Yeah, I knew it was my stepdad.
Well, at first I kind of didn't, like when you first wake up, you're kind of disoriented, and then I remembered that my stepdad was like coming in to take my little brother to school today, so I immediately like knew it was him. And then my uncle I knew was staying, so I knew that was him. And then my mom, obviously, I knew that was her. Yeah.
And then, so you stepped out of your room and you took the bat with you. Is there a reason why you took the bat with you?
Honestly, I think that was kind of just like first instinct. Like obviously I didn't ever hit him with the bat or anything like that. It was kind of just for like security, I guess, to know that I had it. I didn't do anything with it. In hindsight, I probably just shouldn't have brought it out at all because it caused more trouble. But it was kind of just first instinct, and it was right by my bed. So I kind of just like jumped up and grabbed it.
So I'm trying not to put like words in your mouth and stuff.
You're good.
So was there something in particular that you were concerned about that you would have taken the bat with you?
Only if he had been violent towards like me or my mom.
I'm assuming you're talking about your stepdad?
Yeah.
Okay. All right.
Yeah. But it wasn't like, oh, I'm going to take the bat and like do something with it. It was kind of just like, I need something in my hands to like feel safer.
Okay. That makes sense.
Yeah.
So my kind of second dumb question is, and I don't know that there necessarily is, but I always kind of want to make sure, is there anything that, we didn't talk about or I didn't ask you about, or anything that you think is important or anything that I should know? Because it's harder for you because you were there, and so I'm asking questions about something I didn't even see. So I just want to make sure, like, I didn't miss something, or anything that you think I should know about?
That was pretty much it.
Okay. And if you think of something, you know, in 5 minutes and tomorrow or whatever else, we can always talk again. It's totally fine. So, I talked to your mom about, we have some victim services people that work here. They're not cops. They're really good at what they do. So I really want your mom to talk to them, because I think it would be good that your mom has, and you guys have some, maybe kind of some extra support if you need anything kind of moving on.
Mm-hmm.
So I'm going to check in with your mom real quick, and if she's good to go, then I'm going to introduce one of them to you guys. That way you guys can talk before I take you guys back. Okay? Sound fair?
Yeah.
Okay. Do you have any questions for me at all?
No,
okay. If you do, let me know, okay? Okay.
Okie dokie. We're going to take a quick break on that one because apparently this goes even longer. And we've been signing. What time? I don't even know what time it is. I lose track of time when I sign.
44, what? 4:44 your time?
2:44 my time. Let's see. This is like 2 hours worth of video. My gosh, that's a long time for her to be alone. Okay, that's it. Okay, that's it on that one. We have the brother's testimony that I really wanted us to go over. Then we're going to listen to some of her friends' testimony. We're just going to go back over certain people's testimony.
Okay.
But
okay.
The brother states questioning. And we kind of touched on it a little bit about the enchiladas, rice and beans. Do you know Doris Day, one of my favorite singers of that era, had a song, enchiladas, rice and beans, gotta have 'em, I love 'em.
No.
Really? Every time he walks by, he closes my door.
Me, it's sitting on the dock of the bay.
Yep. Can't go any further. What I sang is copyright free. Yours is not.
Oh, okay.
Lori and Alex investigated a fight with Charles, so they think they could unalive him in self-defense.
Unalive him.
That's a possibility that they did instigate it, and that wouldn't surprise me at all.
Yeah.
So we are now 4 minutes into the, we may not have a verdict today, y'all.
Well, probably.
Is Minnesota 1 hour behind me?
I don't know. You're asking me?
I'm Central Time. What time are they? Yeah. Oh, I got it. My Instagram just decided. Let me get my Instagram back in.
Bring it up. Bring it up.
Oh, let me see if I have the key. No, I don't. I got to go get it from Instagram. I got to start it again. They say 1 hour. My gosh, we've been on all day.
Yeah.
Live video, create a title. We're going to do. Okay, got that part done. Audience, public, next.
Next.
Copy. Go here, go here, go here, paste. Save changes. Instagram, go back to, and it won't let me go live. Oh, well, I'm not going to worry about it. Although I am so blessed to be having so many people watching today. Thank you so very much. If you're new to our channel, welcome. If you like our channel, please click the like button, comment, ILIKED. Let me find one to show you.
Like it did.
At the end of the day, I do a drawing for an entry into the end of month giveaway. There we go. Jasmine did it. So at the end of the month, I will do a drawing today. The winner of that drawing will be in the end of the month $50 gift card giveaway.
You know
And
what?
I'm still waiting to hear from last month's winner.
I tried to do it, and that wouldn't let me get in it.
I have no idea. We'll have to talk about that later.
Yeah.
But we are currently in verdict watch for the Linda Sturmer trial. We are currently at 6 hours and 7 minutes. Some people 10 minutes, depending on when you started your particular clock. Right now, we are also on the wait. I mean, it's been 5 hours. We've been waiting for the lawyers to exit the court for the Menendez brothers. And I'm shocked it's taken this long. We are getting ready to listen to the hearing, the testimony of Lori Daybell's brother. We've got fabulous captioning. Diane, are you good for the day or you want to go some more?
Oh, I can do a little more.
Okay, we'll do a little more.
Hey.
And-
Don't get 50s.
I'll be the
At the end of June of 2019, do you recall Charles sending you some emails that were purportedly written by him asking Chad Daybell to come out to Arizona and write a book for him?
Yes.
And did you, without going into it, did you review that email?
Yes.
Did you know Charles, what he had done in his life prior to selling insurance?
Yeah, I know that he played minor league baseball.
And in this email was the person pretending to be Charles asking about writing a book about his career?
Yes.
Was that something you knew Charles was not interested in?
No, he's not, or wasn't.
After you saw those emails that Charles had forwarded to you, where someone was reaching out to Chad, were they inviting Chad out to Arizona?
Yes.
After reading that and getting that forward and talking with Charles, did you believe that Lori was having an affair with Chad Daybell?
Yes.
Did you and Charles spend time talking about that?
Yes.
Was he kind of, I guess, in a tailspin? I'm not sure the best words to say from learning that.
Yeah, he seemed a little desperate.
Did Charles have some idea on how he thought he might be able to get Lori back into the LDS faith?
Yes.
What did you understand that to be?
Charles just thought that Lori was going overboard and that she was going to the temple like 5 times a week, and that's not normal in our religion, and that she was going a little off the wall. So he figured that if she got her temple recommend taken away from her, that she would come back to normal, who she was before she started in all this things that she was believing.
Now, you told us that you had heard yourself some ideas by Lori that were outside the LDS religion. Did Charles also tell you about other things that she had told him?
Yes.
Okay.
What the heck is religion? Religion. Brain cramp.
Well, it's called tired.
And so,
what?
It is called tired.
Yes.
Did you talk with Charles about something that we'll term an intervention?
Yes.
What did you mean by an intervention?
Intervention means Charles he's kind of desperate because nobody in our family would talk to him. I'm sure that, Lori had told people in our family not to talk to him. So he thought that, having an intervention would be getting in front of her, recording her, giving it to the stake president, or having the stake president hear what she was talking about and hear the crazy things that she was saying.
So the intervention was part of the way to try to get her to come back to the mainstream LDS beliefs.
Yes.
Did Charles ask you to help him with this intervention?
Yes, he did.
Did you guys have a specific plan, like on X date at X time, we're going to do this?
No.
Had you talked to Charles about potentially going to Lori's and recording her on your phone?
Yes.
Did you talk to Charles and text him about another idea of having a family dinner and again recording her so that you could play that for the stake president?
Yes.
We're using a term there, stake president. Who is that? What is that in your religion?
Well, in our religion, we have our churches organized where we have wards, and then a bigger, like 4 or 5 wards that are in a stake, and then there's a president of the stake, and so it's somebody who's in charge of everybody in the stake.
Okay. So
they're calling it STAKE, not state.
Not a state and not a snake, but a stake.
It's a stake.
S-T-A-K-E.
Basically, he's like a governor to a state.
Ooh, my hair's going to fall off.
Well, wiggle it more.
I'm about ready to take it off.
Just take it off. Take it off. Take it on.
Hang on, I will get it situated.
You and your falsy hair.
Me and my falsy.
Someone that's pretty high up in the church.
Yes, yeah.
And so the idea was to bring any of these recordings to show she's saying these things to his attention.
Yes.
Okay. And again, the point of that whole was to just try to take away her temple recommend.
Yes.
So on July 9th of 2019, did Charles talk to you about him flying you out so that you can help him with this intervention?
Yes, he did.
And did he offer to purchase your flight
Yes.
to bring you to Arizona?
Yes.
At that time, did your parents live here in Arizona?
Yes, they did.
At that time, was Lori here in Arizona?
Yes, she was.
And you told us your brother Alex was living here as well at that time?
Yes.
Was your sister Summer also living here at that
time? Okay. I'm bad at my states because I never use them. What's Arizona?
Arizona.
Not AZ?
Nope. Arizona. I lived there. It's Arizona.
Yeah, and they're regional signs, and I accept your regional sign.
That's the state sign, Arizona. Little easier than
this is Texas, and it's Texas.
It's Texas.
That time?
Yes.
Yeah.
And after Charles purchased your tickets, did you reach out to anyone in your family to ask if you could stay with them?
Yes.
Who did you reach out to?
Alex, my brother.
And did he offer to let you stay with him?
Yes, he did.
Were you supposed to fly in on the next day, July 10th?
Yes.
So your understanding was when you flew in on the 10th, you'd reach out to Alex and you'd spend the night there?
Yes.
Did you end up staying with him?
No, I did not.
So when you landed in Phoenix on July 10th of 2019, do you recall what time of the day it was approximately?
Sometime around lunch.
Okay. And did you reach out to Alex?
Yes, I texted him as soon as I landed.
Did you get a text response back?
No, I did not.
Was that unusual?
Yes.
So he's expecting you, right?
Yes.
Did you try calling him?
Yes, I did.
Did he answer your phone?
No, he did not.
Again, was that unusual to you?
Yes.
Did you think anything was odd at that time?
Yeah, at first I was like, he can't be that busy. He knows I'm coming.
Did Alex ever respond to you on the 10th?
No.
So he ghosted you.
Yes.
What did you think when you didn't hear back from Alex?
I just thought it was very strange and bizarre.
Okay. So you were supposed to be staying at Alex's. When you talked to him on the 9th, did Alex ever text you between when you guys talked and when you landed saying, oh, I'm going to go stay at Lori's?
No.
Did Alex ever call or text you and tell you, you know, I can't have you stay with me. I know I initially said okay, but not anymore?
No.
So he just ignored you.
Yes.
Where'd you end up staying?
My mom and dad's house.
Okay. On July 10th, did you understand Charles was also flying into Phoenix?
Yes.
Did you see Charles on the 10th?
No, I did not.
Did you see your sister Lori on the 10th?
No, I didn't.
What's the sign for Phoenix?
Phoenix.
That's like Texas.
It's still Phoenix.
Oh, get up.
Not.
This is a T.
So
No, we
you
do
told
it.
us you stayed with your parents. What did you do on the 10th?
They picked me up and we went to lunch. And then we just, I think, hung out at the house.
You said your son Zach lived here at the time?
Yes.
Who was he living with at that time?
I think he was living with my mom and dad.
Okay. So although you didn't talk with Charles on the 10th, did you have an understanding of what he was going to do the morning of the 11th?
Yes.
What was that?
He was going to go pick up JJ, his son. It was his turn to, I guess, have him for a few days or whatever.
Were Charles and JJ really close?
Yes.
So the morning of July 11th, you were not expecting to get together with Charles at 7 in the morning, right?
No.
Did you get a text message from Charles?
Yes, I did.
And did you learn where Alex was?
Yes, I did.
Where did you learn Alex was?
Alex was at Lori's house.
When you learned this, was Charles texting you sort of in real time as he is coming to the house?
Yes.
Explaining to you what he's seeing and what's going on?
Yes.
And are you responding back to him?
Yes.
So you're at your mom and dad's house when you start getting these text messages from Charles?
Yes.
When you learned that Alex was at your sister's, what were you thinking?
I just thought something weird is happening because he never answered my text the whole day I was there, never returned a call. And then all of a sudden he said he's at Lori's house. And I didn't even know what to think at that point. I thought something was off.
So immediately.
Okay, I just want to make sure I was correct, and I am correct. It's an X, and you draw number 7.
Yep.
Half of a T.
Yep.
Not a T, and you draw a T. It's an X.
It's Phoenix.
I was correct.
You're
So the
correct.
sign for Texas and Phoenix is the same. It's on the mouth.
It is on the map. Phoenix. 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 Like feather bean. Feather bean. Yeah. That's it, darling. You got it.
What are you looking for, girlfriend? You're supposed to be interpreting, not scavenging.
My hands is dry. I was looking for my lotion. I don't know what I did with it.
Y'all, when you sign with dry hands, it is so uncomfortable.
It is
I'll
very
find it till you find it.
You knew something was off.
Yeah.
From the prior day where Alex ghosted you to now he's at your sister's that morning when Charles was going over to pick up JJ.
Yes.
Were you concerned that Alex was at your sister's house?
A little concerning, yes.
Have you seen text messages that you and your brother-in-law Charles had, sort of making the flight reservations and leading up to the morning of the 11th?
Yes.
And were those all messages that you two had as you're trying to figure out how to have this intervention?
Yes.
And then ultimately, what you are seeing and saying that morning at 7:30 in the morning?
Yes.
What?
I had said put us on pause because I wanted to explain. One of the really hard things to do when you're team interpreting is to get the rhythm right in the respect of me not answering the question before you finish asking it, or vice versa.
Well, and there is a slight delay
There really is, and a lot of people
in
just don't
this
realize it.
transmission. I am 6 to 10 seconds behind in Facebook,
Yeah.
where YouTube could be 3 seconds, Instagram can be 12.
Yeah.
So if it looks like we're right on top of each other, it's really in the delay.
Yeah. Oh, and that's good to know because I'm like, I just answered that question before you ever said it. And so I answered it a second time. I'm like, what? Okay.
It's okay. Deaf people understand.
That's good. Let's do it again.
And I've shown defendant Exhibit 210, if I can have a paralegal approach with that.
Good.
How do you sign paralegal? I do law assistant.
Yeah, that works.
Adam, if you can take a look at those and let me know if you recognize those as text messages that you had with Charles, sort of the 9th, 10th, and 11th, as you are interacting leading up to that morning and including the morning of the 11th.
Yes.
Your Honor, the state will move to admit Exhibit 210 pursuant to 8031 as present sense impressions.
Yes, Your Honor, we object in lieu of that is a report and not the full extraction.
All right, well, may I see that particular objection wouldn't prohibit admission, it would go toward weight, but give me a second here.
To may publish it then, Your Honor.
Someone needs to stop bringing Dr. Peppers to my office.
I'll admit 210.
And if I may publish it then, Your Honor. And if I could have the elbow. Thank you. Adam, I'm going to start sort of going back to, in Exhibit 210, the conversations that you and Charles were having as you're trying to come up with a way to have this intervention, all right? So you learned that Charles was reaching out Well, let me ask you this. You had learned from Charles about this fictitious email, correct?
Yes.
Did you learn that Charles had reached out to Lori about it?
One more time?
Did you learn that Charles had reached out to Lori about this email?
Yes.
Did you learn that he had reached out to Chad Daybell's wife about it?
I think I remember that.
These are text messages. Were you also receiving emails from Charles?
Yes.
Does this sort of array of messages start to involve where you and Charles are talking about having you come out to Arizona to help with this intervention?
Yes.
And so do we see on the 9th you letting him know that you could fly out tomorrow and come home Saturday or Sunday?
Yes.
Do we see as you continued on, he tells you that he could fly you in on Southwest, and he's telling you he's just right now landing in LA, right?
Yes.
And you knew he traveled a lot for work.
Yes.
When we get to the 9th at 9:11 a.m., did you get a message from Charles about how you were going to get everyone together without Lori knowing that you're going to have this intervention?
Yes.
And is that one of the ideas where you indicated that I'll go see Lori at her house and have a talk with her and keep your phone on record?
Yes.
So that was sort of one idea of a potential way to show the stake president that she was having these ideas outside the LDS faith?
Yes.
Does Charles kind of tell you he's not sure that that's really going to work?
Yeah.
He says, I think she'll leave, but it's worth a try.
Yeah.
Did you then suggest also have a family dinner with everyone and then say, always leave my phone on to record what I say and what everyone else says?
Yes.
And then you go on to say that's to have proof for Holmes. Who's Holmes?
President Holmes. He was our stake president, or their stake president.
You were in Wichita, but he was the stake president here.
I lived here before, and he was in my ward, so I know him.
So when you're talking about the stake president, Holmes is who it actually is?
Yes.
Okay. On the 9th, does Charles tell you that, got it, but honestly, if you, Zach, Brandon, and me go to him, that should be enough? She will feel like we ambushed her, but something has to be done. She'll be real careful what she says. Had you brought Brandon into this yet? Like, did you have a plan to have him come with you?
No, but Brandon played basketball with us on that night. So me and Zach and Brandon played basketball where President Holmes played basketball at a church. So that was that reference.
Okay. So you thought if we go to the church, Brandon will be there and he can help you talk about
say
this.
that, yeah.
Okay. But Brandon's not part of this conversation right here, right?
No.
Then does it kind of go back to Charles asking for your information so he can make your flight reservations?
Yes.
Okay. Then at 1:13 p.m., does Charles let you know that your flights are booked and that he emailed that to you?
Mm-hmm.
And then does he go on to say, I'm really uneasy about how she will respond, not only to you, but to me and Zach and Brandon, right?
Yes.
In talking with Charles and this intervention, was there a constant concern of how she would respond to trying to take away her temple recommend?
Yes.
Was some of that based upon your understanding of the things she had said to Charles in the past?
That and others. Apparently, Lori was flighty. when Charles tried to serve her divorce papers, she disappeared and nobody knew where she was. So in Charles's mind, that she could be flighty and just take off again, where nobody would know where she is. So there was some definite reference to that as well.
Okay. Then it goes on to say, I'll pick up JJ and take him to school. So you knew what he was doing that next morning, right?
Yes.
And you said she'll be there, right?
Yes.
Friday the same. So you knew his idea was he was going to be with his son in the mornings, Thursday and Friday?
Yes.
And then you said she'll be highly suspicious about recording. If you can bring a second device and put your phone on the counter or turn it off, it might help. Is that sort of the same idea that he was unsure that she would trust you showing up there and trying to ask her about those things?
Yes, this was all just it seemed like Charles was just desperate, and he wanted to do anything he could this last ditch effort to try to shake Lori loose of whatever she was under, some spell that he said. So, that's basically what happened.
And then does he go on again to talk about that he really thinks the only thing that's going to break her out of this is going to Holmes?
Yeah. Yes.
And that she's hurting too many families and that he's upset his is gone.
Yes.
Does he say that he still loves her?
Yes.
And does he think that she's basically potentially gone forever?
Yes.
And then we see that he corrected slots to Lori, right?
Yes.
So, typo?
Yes. Lots of typos.
On July 10th at 3:34, do you get a text from Charles asking if you're in Phoenix?
Yes.
And do you respond, yes, you're going to Summers, and that you'll call him?
Yes.
And then does Charles let you know he's got a meeting, but he'll try to call you before he goes to see Lowe? Who is Lowe?
Lowe is Lori.
So people would call her Lowe or Lolo?
Mm-hmm. Yes.
Do you remember if you talked to Charles on the 10th?
On the 10th? What day was that?
The day before. So when you flew in, did you ever talk to Charles?
No, I don't remember talking to him then.
So even though you guys had attempted to call, you don't recall if you ever spoke with him that evening or afternoon?
Right.
So at this point, you'd said you went to Summers in the text messages, and then later you stayed at your parents' for the night?
Yes.
And then you knew that Charles would be going to pick up his son the next morning. Did you assume that you and Charles would meet up or talk sometimes later that day?
I figured so.
Okay. But you had no scheduled timeline for that?
Nothing planned.
Okay. So next in Exhibit 210, we see text messages from July 11th of 2019 at 7:35 a.m. where Charles texted you, Al is here. And then just a couple seconds later, he said, at Lori's. Was this shocking to you?
Yes.
And what did you respond back? Did you say, really, I wonder why he never called me back?
Yes.
And then we see that you wrote at 7:36 and 28 seconds, they are planning something. Why did you write that?
Because Alex not answering his phone the whole day and me calling him and texting him, not knowing where he's at. Nobody in my family said they heard from him or knew where he was. All that is very suspicious to me. And then Alex being at Lori's house that morning felt like something was really off.
So when you told Charles they're planning something. Charles responded back, absolutely. Did you then let him know that you were supposed to spend the night at Alex's house? She probably blocked that.
Yes.
Did Charles respond to you, what you do is up to you?
Yes.
So were you kind of upset at your brother for telling you you could stay with him and then ghosting you, ignoring you?
Yes.
Were you upset at him for being at Lori's house when Charles was going there just to pick up JJ?
Yes.
Did you then text him, I'm going to put the pressure on to have him come get me right now, see what he says?
Yes.
Did you in fact text your brother?
Yes.
Did he respond back?
No.
As we're going along here, we see that each of these are being read sort of in this short period of time, these couple minutes that Charles is here as he's driving in. After you texted Charles about putting the pressure on to have him come get me right now, did you then say okay to Charles?
Yes.
Sorry.
And then we see again that at 7:49:34 a.m., you texted Charles, me and Zach are going to the steak center tonight at 8 to.
Okay, we're going to take a quick break. Jeffrey Hoffman, there is my burner phone. I can give you my regular phone number, but I need to do that in a private chat. If you were a part, God, I hope so, of our Discord, please go to Discord, private message me. I'll give you my private cell phone number. And if anybody's out there who has not joined Discord, please do. Ronnie or one of our mods, please put our Discord link up. We are now at 6 hours, 37 minutes for the verdict watch when it comes to the Linda Sturmer trial. I am not sure if they are still going or what the deal is, but we're still on hold. This is our view. And this is our view for this. Okay, we're going to go back to this.
We're at the trial.
Doy. Are you good or you want to go? You turned yourself off. Now I can't hear you.
Good for another 10 minutes or so.
1-8. Oh, we got to be careful, Ronnie. Exy. E-X-E. X-E-X-Y. But join us on Discord. Instant message me. I'll give you my private phone number. That may work better, but in the meantime, you can call the burner phone. All right, let's do
Why don't you want to
play
put
basketball.
it across there?
Huh?
And why don't you want to put it right across there?
As my sister would say. Which, please? Yeah, I did that once. That was a big mistake. I still get people watching that live and calling.
Ball. Holmes is always there, either playing ball or interviewing people. I will try to catch him and have a conversation with my old friend.
Yes.
What was that about?
That was just part of the plan that Charles initially came up with to somehow get in front of the stake president. So that night, he's the stake president. He interviews people for Temple Recommends and also plays basketball afterwards. So that was just a thought of maybe this could be something that we could do to help with that situation.
Okay. Now, up until 7:37 and 7, you had been interacting with Charles, right? You would respond and you were getting some text messages back from him.
Yes.
We see after 7:37 where he texts you, what you do is up to you, that he didn't respond back to any of your other comments, right?
Right.
So when you sent him at 7:37 and 29 seconds that you're going to put the pressure on him, you meant Al?
Yes, Alex.
To come get you, Charles didn't respond to that?
No.
And in fact, it shows that that message was read at 12:13 p.m. versus the earlier messages that were read sort of right in time.
Mm-hmm.
Is that yes?
Yes.
And when you told Charles that you and Zach were going to go to the stake center to play basketball and see if you could find Holmes, did you get a response from Charles?
No.
And again, we see that that was read at 12:13, correct?
Yes.
Did you go talk with Holmes that night?
I went to go play basketball, but he wasn't there.
Was it just you and Zach?
Yes.
During the day of July 11th, at any time, did you learn that Charles Vallow had been shot?
No.
So Lori did not call you and tell you that Charles had been shot?
No.
Alex didn't call you to tell you that he'd shot your brother-in-law?
No.
Anyone in your family talked to you about it?
Nope.
How about the next day, Friday, July 11th? Did Lori tell you Charles had been shot?
No.
Alex contact you to tell you that he'd shot Charles?
No.
Anyone in your family talk to you about that?
No.
Did you decide to go visit a friend in Tucson on Saturday the 13th now?
Yes.
What were you going down there for?
Going to see my friend Eric.
And did anyone come with you?
Yes, Zach did, my son.
Okay. When you went down there, did you talk with Eric about what's going on?
Yeah, I just thought it was
What is the sign for Tucson?
really fishy that I heard from Charles. And I didn't know if he took JJ and just was having one-on-one time with JJ. I didn't know if Lori and him were getting back together and Lori told him not to talk to me. Or my mind was spinning. Like I had no clue what was going on.
Had you talked to any of your family about it? Were you still keeping that intervention thing secret from them? At that point?
No, at that point, but I think nobody had heard from, I asked if anybody had heard from Alex, and nobody said that they heard from Alex in my family. But at that point, I was there spending time with my son, Zach, also to help Charles with what he wanted to try to get an intervention with Lori, and also to see my friend Eric, because I live in Wichita, so I was trying to do 3 things at one time on my short visit.
So on the 11th or 12th, though, were you still keeping that sort of secret that you and Charles had been wanting to do an intervention on Lori?
Yes.
You weren't telling your family, like, I don't know why we're not doing this.
Charles asked me not to tell anybody.
And was that actually sort of a message you guys had talked about of who in your family might be, might prevent any type of intervention?
Yes.
And who in your family were you guys concerned with if they learned about the intervention might try to stop it?
Mom and Dad, Summer.
Alex, too?
Alex, yes.
So even though you're here and you're seeing your family and you're seeing your son, you don't want to tell them a lot about Charles because you're trying to still keep that quiet in case he does want to go forward with it.
Exactly, yes.
So you're in Tucson and you start talking to your friend about Charles.
Yes.
Do you learn at some point that Charles has been killed?
Yes. I was talking with Eric saying something doesn't feel right. I haven't heard from Charles, and usually he would text me or send me a message or something. And then Eric asked me, he goes, well, what's his last name? And I said, Vallow. And he was on his computer and he just Googled Charles Vallow. And he said it popped up that he's been killed by his brother-in-law.
So you learn this. What is going through your mind now?
Just everything, chaos. That is not in my stomach. Just probably one of the worst feelings I've ever felt in my life.
Obviously, you had been concerned that something was being planned when you told Charles that on the morning of the 11th, right? But
well,
not that.
Not that, but yeah, it felt like something was off. That why Alex would be at Lori's house that morning.
Did you know your brother Alex to carry guns with him?
Yes.
Did he regularly go shooting with guns?
Yes.
Okay. Prior to Charles being shot and killed, did you ever tell Lori that you were going to be trying to do this intervention with her?
No.
Prior to Charles being shot, did you ever tell Alex, hey, I'm going to stay with you, but we're trying to do an intervention with Lori?
No.
What about your parents? Did you ever tell them you were going to try to do an intervention?
No.
Your sister Summer?
No.
So if your sister told detectives a couple hours after Charles was shot that she was confronting Charles about you and Charles talking and texting, it wasn't something that you told her about?
No.
You told us that you are LDS. Have you ever taught Sunday school?
Yes.
Can you tell us about the story of Nephi?
Nephi?
Mm-hmm.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him. And Nephi was told to kill Laban.
Who was he told by?
The spirit, or, yeah,
Okay.
God.
So God was using a Holy Spirit to tell him to kill Laban? And
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
So was the concept that it was better for Nephi to kill this one evil man and sort of benefit the nation and his descendants?
Yes.
Were you aware that that your sister had told people that Charles was possessed by evil spirits?
Yes.
Were you aware that your sister had told people that your brother-in-law Charles was dark?
Objection. Calls for hearsay.
It's whether or not he was aware of it.
Whether or not
Yes or
he's
no?
aware, he can answer yes or no.
Yes.
When you and Charles were talking about this intervention, were you trying to help your sister come back to mainstream LDS beliefs?
Yes.
So it wasn't just Charles, but also her.
Yes.
You told us that your friend had Googled and learned that Charles was killed, did you know at that time it was by your brother Alex?
That's what the article said. So yes, he told me that.
What did you do after you learned that?
Freaked out for a little bit, cried, didn't know what to do. Thought my world was coming apart. Then I got angry a little bit, and then called first thing I did, I called Kay, who's Charles's sister, and asked her, because she's the only one that I felt safe calling after knowing my family was involved in this or thinking of this, that I asked her if she knew that Charles was dead, and she said she just learned of it too.
Did you learn from your friend when, because it's now the 13th when you learned this, right?
Yes.
Did you learn when that happened?
Yes, I did.
So you knew on that Saturday, the 13th, that Charles had been killed that morning
Yes.
of July 11th.
Yes.
Did you ever come back to Phoenix and confront anyone in your family about this or talk to them about it?
Yes. After I talked to Kay, then I called my mom and asked her if she knew that Charles was dead. And she said yes. And I said, what's going on? And she said, you tell me what's going on. And at that point, I thought that was bizarre that she would say that. So I said, well, we need to sit down and talk. And she said, yes, we do. And so me and Zach got in the car and drove back to Phoenix.
Did you go to your mom's house?
Yes, I did.
Did that conversation go well?
No.
Did this create a break in your relationship with your mom?
Yes.
Did you stick up for Charles?
Yes.
Did sticking up for Charles create issues between you and most of your family?
Yes.
Did you continue to stick up for Charles even with that happening?
Yes.
After you had that argument with your mom, what did you do?
Me and Zach left her house, and we were staying at Summer's house, my sister, who was away on vacation. And we were staying at her house, and we went back to her house. We were watching her dog.
You were supposed to leave the next morning, Sunday, to go back to Wichita. Did you return back home?
Yes, we did.
Did your son go with you this time?
Yes, he did.
After this whole incident happened, did you not talk with your family for a long time?
Yes.
Did it cause a lot of friction in your family?
Yes.
Have you started to try to talk with your family some?
Yes.
I have no other questions, Your Honor.
Cross?
Okay, Miss Diane, thank you very much, my dear. We appreciate and love you. Bye-bye. See you maybe Monday morning. We'll talk to you later. All right. Love you. Bye. Okay. I am going to take a break from signing. We're going to keep listening.
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So, has it been a year, 2 years, 3 years, 5 years,
Something
6 years,
like that.
7 years, 8 years?
Something.
Okay. So, you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay, so did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house.
I did see you at that house, yes.
At least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember that.
Okay. And when was the last time that we had a phone call or text message?
I have no idea.
Could it possibly be around that exact same time?
Possibly.
Okay. So that was possibly in early 2018?
Yes.
Okay. Who do you think initiated the final communication in our relationship?
Who concluded it?
Yeah.
I don't know.
So right now it's 2025, is that correct?
Yes.
And so we haven't spoken in about 8 years? Would that be correct?
Probably 7 or 8 years.
Okay. So would you say up until that point that how often would we communicate before that?
Before what?
Before 2018?
Probably on a regular basis. Once a month, twice a month, 3 times a month.
Like a call or a text message?
Yes.
Just keeping in touch?
Yes.
You know of us living in Hawaii and you were living in Kansas at the time?
Yes.
And in your career, you lived in lots of different places, is that correct?
Yes.
Austin?
Yes.
Dallas?
Yes.
New York?
Yes.
Wichita?
Yes.
Sacramento?
Yes.
Did I miss anything?
Others.
And I was in Texas?
Yes.
Arizona?
Yes.
Hawaii?
Yes.
So would you say that we were not physically close during the past 20 years?
Yes, I would say that.
So our communication would be solely...
Okay, toxic. Let's talk about how Lori's doing. Lori's opening doors. The only thing that she's doing well that I've heard is that she's asking, did you ever see me, hear me, communicate that I was conspiring to commit redrum. That said, other than that, she's opened some doors. She's not walked through some doors that she should have, but it does get a little, leave it alone, sis. It does get a little spicy.
Family get-togethers, occasional text messages.
By the way, I'll move myself so y'all can see this. See that little bulk right there? See that bulk right there? Y'all know what that is? Y'all want to know what that is? That's the... Again? So she gets out of control. She gets a zap. Oh, yeah. We're going to watch that again.
Is that correct?
And phone calls, yes.
Okay. So, Mr. Cox, did you see or hear or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
Yeah. she is more interested in the enchilada dinner than she is the actual act of the unaliving.
Repeat that again.
Okay. Did you see with your eyes, or hear with your ears, or personally witness me conspire with my brother, Alex Cox, to murder my husband, Charles Vallow?
No.
Thank you. No more questions.
Redirect.
Have you talked to your sister since Charles was shot and killed?
No.
So, since that happened, you cut off all communications with her?
Yes.
Prior to that, you were being asked about 2018.
Uh-oh. Didn't mean to do that. I get it. First, I have a real taser, like the cops carry. I have a real one. So, Gerald, don't piss me off. No, I'm kidding. But I do have one. It's not as fancy because those are like $1,300, but it works. It works.
Being at Lori and Charles's house. Was that the time where Lori told you she was becoming a celestial being?
Yes.
And the time where she was telling you other ideas that were not in line with the LDS faith?
Yes.
After you had heard those statements by your sister, you told us that she had asked you if you thought she was crazy, right?
Yes.
And you had responded back how?
I don't know if you're crazy, but what you're telling me is not true.
After you told her that her beliefs were not true, did that sort of end your talking with her?
Yes.
You were asked if you personally saw, heard your sister Lori conspire to kill Charles. Were you there that morning?
No.
Were you the person who was supposed to, though, be with Alex on the 10th into the morning of the 11th? You spent the night with him?
If I would have spent the night with him, yes.
So that stood out to you because you had made plans with your brother, right?
Yes.
And instead, you learned he was at Lori's house.
Yes.
You told us that you thought it was odd that your brother would be over at your sister's house at 7:30 in the morning.
Yes.
And you were aware that your brother had.
Toxic. We are so sorry you're having to move, but once it's done, it's done. Once it's done, it's done. You have to catch me. And I did say taser. I'm just being facetious, honey. I'm being facetious, honey. Ronnie, that's a judge has been feeding them. Maybe they're waiting for one last good meal. More pizza. More pizza.
Had guns.
Yes.
Charles was going there to pick up JJ, right?
Yes.
And so did it seem odd to you that your brother would bring a gun that was loaded with extra magazines that was not safe to your sister's house where JJ was?
Objection, out of scope. This is not just
Goes to the
a
conspiracy.
redirect. This is not just a redirect.
Hey,
Whoa!
didn't ask for argument. Okay. The objection's overruled.
What's the question?
Sure. Did it stand out to you?
He's like
that
that one, boo. And I'm all like,
brother who knew JJ.
Hold on, guys. I got to see if I can do this. Microphone. Hello?
Hi, Anna Kay.
Hey, wait a minute. Can y'all hear him? I have some. How are you doing, sir?
Good. How about you?
I'm wonderful. So,
I will
what are
be at
your
Lori's
plans?
trial on Tuesday.
You're going to be in the trial on Tuesday.
Yes.
Oh, honey boo. So, tell us what your anticipation is going to be.
Just see what she looks like and see who's all there. I will keep you guys updated.
Awesome. This is Mr. Jeffrey Hoffman. He's going to be our eyes and ears in court on Tuesday. Are you just going to do Tuesday or you're going to other days?
I'm going to do Tuesday, and hopefully they say when the trial's going to end, and I'll be there for the verdict.
Yay! I will send you a blessing at the end of the trial for keeping us in the loop and calling and reporting in.
Okay.
Wonderful. So, do me a favor, text me or put in the comments, Ada, calling in 5. So I make sure that I don't miss your phone call because I'm deaf and my phone blinks. So I know somebody's on the phone.
Okay. Thank you.
All right. Thank you. Have a great day. Have a safe journey up there. And we cannot wait to hear from you.
Okay.
Thanks. Have a good day.
Yep. You too.
Bye-bye.
Bye.
Woohoo! We got somebody in the house on Tuesday and on verdict. Yes. Okay. Thank you so much, Jeffrey. It's so good. That sound was good and clear. That is awesome. That means I'm working on my end too. So we haven't had anybody call in a while. So yes. Okay. Back to this. I'm excited.
Would bring a loaded gun and extra ammunition to the house where JJ was running around.
Well, I didn't know at the time.
Yeah.
You're saying afterwards?
Yeah, you learned afterwards your brother killed him, right?
Yes.
And when we're talking about this conspiracy and things that are going on, did that seem odd to you that your brother would bring a loaded gun and extra ammunition in a unsafe way to a house where your sister's son, JJ, lived?
Yeah, it seems extreme.
When you were talking to your family after this happened, did you actually tell them that you believed that Lori and Alex had conspired to kill Charles?
Yes.
Why was that?
Because Lori had told people that Charles was no longer living, that some guy named Ned was inside of his body, that there was a zombie living inside of him. And Alex didn't respond to any of my text messages when I was supposed
That's a sign for zombie. I love that sign.
to be with him. And he was at that house that morning. Lori talking crazy about how she's a translated being. All these things all added up into that moment and that morning. Once I found out on Saturday that Charles was shot and killed, no doubt on my mind that they killed him. That's a feeling that I got.
And you told your family that?
Yes.
No other questions?
The last line of questioning from the possession of the gun on, I think the defendant's right, was technically beyond the scope of her cross. So based on that, I'll allow the defendant, if she wants to recross on those issues, if she elects to, may do so now.
I don't know. Has she been flirting with the jury? Anybody know? Anybody know? Has she been flirting with the jury? I don't think so. She's been pretty focused.
No questions, Your Honor.
All right. Are there any questions from any member of the jury? Not seeing any, sir, you can step down. You can step down.
We're done with that. We're going to go over to her sister now. Uh-oh. Uh-oh. What do we have? Hold on. We have people coming back into court. We may have verdict, y'all. They're coming back into court, so it may not be verdict. This is live right now. People are coming back into the courtroom, a lot of them. This may be the end of the day. I'm hoping not. It is. They've ended about 4:30 before, so yeah, I think this may be the end of the day. We'll see. It's almost 5:00 their time. God, I hope we have a verdict, but I am not holding out. I'm suspecting that this is end of day. And right now we have 227 alternate jurors on X watching us. And thank you so very much for all my YouTubers who are watching us. It's been a good day. It's a good day. Where is it? Where's it? I got to do it. I got to do it. I got to do it.
We had a good day. It was a good day.
I just have to do it. Jeffrey will let us know. Yes, he will. He'll let us know. My biggest thing is what is the jury's overall mannerisms and what are they doing? Although you can't really hold much, you can't really declare much by that, in all honesty. You can't. Just got back from appointments. Is this still the same stream as this morning or is it all new? And it's the same stream. But if you're not sure if you were caught in the drawing because there was a glitch this morning, go ahead and put I liked. If you please click like on the video on YouTube, ILIKE, and you can get in the drawing for the end of the year, end of the month drawing. If you're on X, go ahead and swing over to YouTube. I like swing back to X. The only way I know how to do it. We're all going, has anybody seen anything? They look too relaxed. Although Mama here looks a little concerned. Let's see. You know what? The victim's mother is a lady here in black. This is, of course, all his family. This is the son in purple, son's wife, her son. Yeah. Everybody's coming back in. So why would they do that just to dismiss the jury? So I'm suspecting this is her son, spouse, son, a son. Take the hat off in court, dude. I'm surprised the bailiff didn't make him take his hat off. The bailiff should have made him take his hat off. So these are the family of the victim, of the husband. So we're about 7 hours and 20 minutes of deliberation, I believe. I don't know where Yana is. Yana. Let me go over to Discord and let me see what I got over here. We got to get it all verified. Let me see. Admin, live, Yana. So, we have all the family here. The courtroom is quite packed. We don't know what is happening. Is it home? Is there a question? I don't think they'd be here for a question. And I don't think the courtroom would be this packed. I mean, it's pretty packed, y'all. That's a look of nerves. Those people don't look relaxed. Hmm. To me, it kinda looks like there may be a verdict. I mean, look at the body language, look at the people. I hope it is. I don't wanna be misleading. Matthew, this is what you did. Look at the look of mama. I would think that we may have a verdict. Look at her. Her heart rate's up. Her breathing's more. She that's mama. That is the victim's mother, Linda Sturmer's mother-in-law. And then we have behind. Well, where's the children? The daughter. Okay, Jerry's coming in. Yep. I'm looking at X, but I don't wanna do anything until I have a confirmation. Thank you guys for following me on X. Only vent. We need this, Sturmer trial. Verdict is in, is what they're saying, but it's not verified. We have not verified this. It is not verified. I know, it pisses me on when you have a hat on inside, but in churches, governmental buildings, courthouses, certain places, temples, whatever, you should not have a hat on unless it's a custom in that belief and faith to wear one like the Jewish. Unless it's your faith to keep your head covered, but his head wasn't covered when he testified. That I am saying. I agree, June. I don't like it when they put it on the mom. So, oh, man. Okay, here comes. Oh, no, that's on the other side. Hopefully, there's a verdict. I have not gotten a response from my question. Is this confirmed? We do not have any confirmation yet. I did ask if it was confirmed, but I do not have. Oh, I don't know why I'm thinking this, but okay. How many of you think this is either a verdict or a hung jury? Put it in your comments. Verdict or hung jury. Yana, what is your trial time? I think it was like 7 hours and 12 minutes, 13 minutes, something like that. But is this a hung jury or is this a verdict? Put your comments in below. I'm hoping not a hung. But we do have a person posting. It is in. Tony Green, thank you so much for following me on X. I appreciate it. Appreciate it so much for you following me on X. Michelle, thank you for following me. Patty B, thank you so much. Jim, I liked you so much. I like you. Thank you for liking my reply. Patty B, Boston Brandy, Canton's in the house. Thank you so much for following me. So they would be announced. Well, maybe, maybe not. Maybe, maybe not. I think it's either going to be a verdict or a hung jury because they don't bring everybody else in and take the time. Okay, I have been in trial where my ex was being tried and was found guilty. They didn't even wait for me to get there. So every jurisdiction's different. Well, there are some people saying that it is a verdict. But where are they getting their sources? Yeah, the tweeters out there saying they have a verdict, but nothing is confirmed. I asked several of the tweeters, I said, is this confirmed, please? Thank you for the information. And I'm not getting a response. So I can't emphatically say we have a verdict. Here they come. This is her. I believe that's her daughter. No. She has no jewelry on.
Court calls
No
case of People versus Linda. Counsel are present. Ms. Sturmer is present. I've been advised by the jury that they've reached a verdict. And to members in the audience, please, I know there's a lot of emotion involved, but when the verdict is read, please remain silent. And also, the jury has indicated a desire to leave immediately after their verdict, so we'll all wait in the courtroom, give them 5 minutes to clear out of here. The record should reflect we only had one question from the jury, which was a request for exhibit log. Everybody agreed to provide that to them. And other than that, anything else, counsel, before we bring in the jury?
Oh, I do believe there was maybe a potential question where they asked if they could open a piece of physical evidence.
Oh, I forgot about that.
But I believe that
Right.
I think that was the only other thing.
We have verdict.
Yeah, thank you. I forgot about that one. Anything else then before we bring in the jury? No, we'll bring in the jury for verdict.
Bring the jury. We got a verdict. Hallelujah. Hallelujah. Thank you, Jesus. We got a verdict. Maybe. If it's an innocent, sometimes they want to leave early too because it's against what the popular vote wants. Right now, we have 374 alternate jurors watching on X. Thank you so much. I can't thank all of you. Thank you, thank you, thank you, thank you. And 28 on YouTube. Thank you guys so much for watching. I greatly love and appreciate your support. You're amazing people. Yeah. We still don't have anything on the Menendez brothers.
Jury, I am advised that you have reached a verdict, and the clerk of the court will now accept the verdict. We'll have the foreperson please rise.
Yes, I know. So we'll be doing the Karen Reed live during the day, and then Laura Vallow will be done after that trial is done for the day and for the evening. Which means this weekend I got to get all of my homework.
We, the jury, find the defendant guilty of first-degree premeditated murder. We, the jury, find defendant guilty of first-degree felony murder.
Members of the jury, listen to your verdict as recorded. In regards to count 1,
Give it up, Mama.
guilty of first-degree premeditated murder. Count 2, guilty of first-degree felony murder. Is this the verdict of the foreperson?
Yes, it is.
Is this the verdict of the jury?
Yes, it is.
Okay, you can have a seat, sir, and we're going to poll the jury now.
If you could
Get it
pass
off the
microphone
family. I
to
want to
juror
see
in
her
seat number
react.
1, please. Juror in seat number 1, is this your verdict?
Yes. Yeah.
Juror in seat number 2, is this your verdict?
Yes, it is.
Juror in seat number 3, is this your verdict?
Yes, it is.
Juror in seat number 4, is this your verdict?
Yes, it is.
Juror in seat number 6, is this your verdict?
Yes, it is.
Juror in seat number 15, is this your verdict?
Yes, it is.
Juror in seat number 14, is this your verdict?
Yes.
Juror in seat number 13, is this your verdict?
Yes.
Juror in seat number 12, is this your verdict?
Yes.
Juror in seat number 11, is this your verdict?
Yes.
Juror in seat number 10, is this your verdict?
Yes.
Juror in seat number 8, is this your verdict?
Yes.
Thank you. Counsel, if you can approach to review the verdict form, please.
Get it off of the family and get it onto her. Get it off of them.
Report with the verdict we just
She was
received.
found guilty in her first trial as well. Now that mama, I can't believe that poor family has gone through
Now
this.
received the verdict and confirm that it comports with the verdict received in open court and confirmed by polling. So verdict having been received, I now thank you for your service. This was a very significant and time-consuming case. We were worried we would not get a jury to stay through it all and work through it all, and it was a lot of work. I've never had a jury ask as many questions as you did. So on behalf of all of us here, I want to thank you for a job well done as far as listening to the evidence and paying attention to everything, taking the serious time to deliberate the case as well. So thank you, and we're going to have everyone here wait in the courtroom a bit. I'm told the jurors want to get out of here and go, so we'll stay in the courtroom and give you guys the space to get out of the building, and thank you. And you're done. You can watch the...
I want to see her taken to jail. Back to jail. Why is that not showing? Back to jail and hope now the second bit of apple with another overturn from the appellate court. Yeah, they're going to go to the appellate court. My heart does go out to the children. It is so devastating to them and the the whole family, but the mother and all of the. That's his wife. The lady in the burgundy sweater is a wife. I know they didn't show her, which I wish they would have.
Okay, counsel will need to schedule a sentencing date.
I'm going to see her get cuffed and off. Cuffed off. Oh, well, they cut it. Why are you cutting the live coverage when we want to know the scheduling date?
Okay.
Yeah, that's true.
Okay, counsel will need to schedule a sentencing date.
Why are you cutting it? No. Okay. Y'all, we did it. We got 2 verdicts in 1 day. We need the date. We'll look it up. Yeah, her hair would have hit her face. Well, I guess she's not surprised. I wouldn't be surprised if I was her, but thank God that they got that done. We are done on both of those today. The only thing that we've been waiting on, but we're not going to have, I don't think, is the court in the Menendez brothers. We have up to another, it's 4 something here, that's 2 something there. If I stay live just for that, we're going to be twiddling our thumbs. So everybody, please go to As the Gavel Drops in Discord for all your court document needs. As soon as that date is set, it will be, you can find that information as well over in As the Gavel Drops. They will have the information as soon as it hits the dockets. Correct, Yana, they will. So we'll get that sentencing date. We will let you know. But if you go in Discord, go to As the Gavel Drops.
register and log in and validate your account like you do with me, and you too can have access to all those. So they will have it first. As the gavel drops, it's the number one place for all of us who are doing court commentating to go to find out information. So I don't have any other videos other than we are sitting here waiting patiently for the Menendez. So I think what we'll do is we'll just cover that on the Sunday Night Live. I will be doing my Sunday Night Live. We'll go over everything that happened this week. We'll be going over what's going to happen next week. We will touch on the Menendez brothers at that point. So I just want to give you guys a huge shout out and thank you for sticking with me through this. We've had some craziness with the overlapping of trials. We had 4 trials going at once. It's kind of hard sometimes when you start a trial and you don't know it's going to take 45 days. How many days did the Monica Sementilli actually take? Does anybody know? I lost count after, I think it took 45, 46 days. June, do you know how many days the Sementilli took? It was only supposed to take 2 to 3 weeks, at best 3 weeks, and it ended up taking a whole lot longer. In fact, it almost took as long as what they're expecting the Karen Reed to take. FYI. Karen Reed will start on Tuesday, and we're going to have a special guest in there Tuesday. Oh my gosh. I am so dang excited. Jeffrey Hoffman will be our eyes and ears in courts. He's already committed. He called us a minute ago, making sure he can get a hold of me, that we can get him to call us during the breaks and give us an update of what he's seeing and what it looks like for him and all that wonderful stuff. So I'm looking forward to that Monday, because we are dark on this. Let's see, we don't have Lori Vallow on Monday, do we? We have Lori Vallow. I believe it was 42 plus 2.5. So it's 40. I thought it was basically 44, 45. Jeffrey will be at the Lori Vallow trial. He'll be our eyes and ears for the opening statements and then for hopefully verdict. But do we have Lori Vallow Monday? I can't remember. My brain's fried. Anybody know? My brain is slightly fried. We got to do the light. There, well, we do know that Lori Vallow starts 10:30 Monday because the court was closed today. Okay, that's good. So Monday we'll have only Lori Vallow. Yay! I can sleep in. But come Tuesday, I gotta have my butt in the seat at 6:30 in the morning every morning, as long as we're in trial for the Karen Reed. Karen Reed will be in jury selection Monday. They've got to get 2 more jurors. And then after that, they have slotted Tuesday as the opening statements. I hope they don't push it to Wednesday. That is a possibility. Once again, we have a great showing today. Thank you, everybody, for joining us. Let me do the giveaway. If you are new and are watching for the first time, if you give me a thumbs up and then you put in comments, ILIKED. I don't want to do it myself because then it put me, well, I guess I can just redraw. If you just put this in the comments, ILIKED in the comments, I'll give you a couple minutes. You can be in the drawing for an entry. We do a $50 gift card giveaway at the end of every month. And so please make sure you like the video, comment I liked. If you are on X, give me in X, put I liked in X, and then I will add you into the drawing at the end of the month as well. So if you're in X, alternate jurors, please comment ILIKED, but you got to like it, and I will get you into the drawing. So we have guilty on all accounts for both Sementilli and Sturmer. And I guess Sturmer, I wonder what her sentence was. Was it life without possibility of parole? Yana, take care, love. Thank you so much. You were a fabulous mod. Ronnie, we can't do this without you. You're my number. Oh, well, I think you're the oldest mod as far as, I can't say that. The most longevity mod on my channel. You've been with me since day one. Thank you so much. Thank you, Chris H., for joining us. Virginia Little, LWOP, life without parole. So that's what she got, LWOP. And she will probably get that again. Everybody have a great rest of your day. Don't forget, I'm getting ready to draw. Make sure everybody gets their I liked in before I draw, because we're getting ready to do that. Let me share the screen. Let me get me on this side of it. There we go. We are going to be, no, I need to get this off. I'm bouncing here. There we go. Back to comments. I'm the oldest mod, LOL. You've really been a fabulous mod, and I can't really, seriously, I can't do this without you. And your researching and your papers and everything are phenomenal. By the way, I am still looking for a note taker, if possible, someone who could take really good bullet points on every witness and send it to me as the day goes by in Discord. The reason why is I'm going to try and interpret as much as possible when we have a deaf person on, and I cannot take notes on the witnesses and interpret at the same time. It is vital that I have a note taker. So if anybody is good at taking notes and just wants to shoot me in Discord a bullet point of all the witnesses, you don't have to take detailed details, but the important stuff, I would greatly appreciate it. Otherwise, I will have to be very selective in the interpreting process. So let's go ahead and get going on the drawing. Sweet Magnolia, yay, you won it. Do you know what? We've had so many people on today. I'm gonna draw again. Here we go. Woo, June, congratulations. Yay. And because I love y'all, we're gonna do it again. 3, but we've had so many today. We've got a lot of new people in today. We've got some that have been here for a long time. So I just want to do a special day. Just give out 3 of them. One sunny day. Yay, one sunny day. You have gotten an entry. Congratulations to June. One sunny day. And oh my gosh, who was the other one? I'm tired, y'all. I took a screenshot. I could look at my screenshots. Let me look. Oh my gosh, that is so funny. My brain is totally fried. I think it was Sweet Magnolia. You guys are awesome. You guys are awesome, Mundo. I can't do this without you. I really can't. And guess what? I can't get it. But anyway, thank you guys so much for joining me. You guys are awesome people, and we really help. Yeah, Sweet Magnolia. Congratulations to all of you. We will see you back here Sunday night at 7 for our members only live. Be it I'm well and healthy to do it. If not, I will post in Discord. You know, you never know what's going to happen, but my plans are for y'all to come on and start watching. We'll be live for this is not a members. This is open to everybody. So we'll be live Sunday night for Sunday Night Live. And we will catch you up with what happens with the Menendez brothers. Okay? Thank you guys so much for joining. I really, really mean it. I appreciate you. Y'all have a great weekend. Stay safe and pray for the victims of those helicopter crashes and that airplane crash. And have a great weekend. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.